Great.
Yes.
Okay, we are back on the record in State versus McIver. It is a little bit after our lunch break. The jurors are ready to come back in, but before we bring them in and we have Ms. Clark Palmer perform her cross-examination of Professor Radford, Mr. Samuel, anything you had, before we got on the record, forecast that maybe things weren't going to go real smoothly, or at least folks weren't seeing eye to eye. I don't know where Ms. Convery went, but it doesn't mean you can't give me the defense perspective, because we have now one prosecutor in here, but there'll be more soon, I'm sure.
I sent her an email and told her my problem. I listened to the clips of Mark Winnie and Morse Diggs. Morse Diggs only has one. Mark Winnie, it's a little unclear to me, but they sent me kind of a package of clips from Mark Winnie, which tend to be the same thing over and over again. You know,
It was represented to me there were two involving Mr. Winnie, one in April at Rice Street, one in June at the North Annex.
I mean, it's full of him saying typical Mark Winnie things. Explosive new developments. I mean, are we playing that? Are we seriously going to play that? We got pictures of him in the jail cell, of the client in the jail cell. We got references, with all due respect, of him passing a polygraph. I know they're not going to let that in. We have references to the thorough investigation by the Atlanta Police Department, and now brought charges of malice. You know how Winnie is. It's ridiculous.
Okay.
Now, you know, and the visuals, you know, the indictments floating around, covering his face, you know, and did you know you've been indicted for malice murder? I mean, there's so few things in that entire clip that are relevant or admissible, I stopped taking notes.
Okay. Certainly would be something that would entertain the jurors more than maybe what's been going on. But I hear your points. There sound like there are many of them, probably more because you stopped. You had reached the point of why go any further.
I watched them all, I just stopped taking notes.
Okay.
We also got a message, though incredibly unreliable source, that Winnie has never agreed to come here. That he was just going to authenticate the video as being a video. But I may be wrong about that.
I can speak for the reliable source, and
Okay.
he spoke personally to me on the telephone and said, I will come to court to authenticate these recordings. So
Okay.
he may have changed his tune. But
My source of information is so unreliable, I probably shouldn't have even mentioned it, but I would.
Okay.
It did come to me, so.
That's okay. I have not watched any of these things. It's helpful to hear the defense perspective. I'm good right now. I guess we may, if it's necessary, I'm happy to do it, but we may be where we got with Mr. McIver's statement at the law enforcement, where I took the transcript and said, look, here's the universe that I think would work. But I do want to hear from you, Ms. Convery, as to what your thoughts were. Just taking one of the examples, Mr. Winnie looking in the camera and saying, after a very thorough investigation, X. If the defense objected to that, that's likely an objection I would sustain, but it's not a witness on the stand, it's playing something. And so have you given any thought to identifying the things that Mr. McIver said that you're interested in, so that we could figure out if there is one, a way to get in just that, and two, the way in which we would do it. I haven't worked through yet whether it's anyone's issue than the defense is that he happens to be in a jail outfit in jail. He is where he was when he decided he wanted to talk to the public. So we'll work through that separately, but it sounds like there are things that are said, as you'd expect in a news broadcast that's meant to have some hooks in it to keep the viewer interested, that wouldn't come in.
I agree, and I agree with sort of the court's representation on that would be probably our position on the jail aspect of it. Our friendship broke down over lunch. So
No, I told him it was amicable, we just disagreed.
I'm joking, but I just got his feedback on the issues over lunch, so it is certainly something that we can, they're short clips fortunately, so it's something we can look into and maybe splice out the relevant portions, just like we did I think we did harder, because of the format that it's in, but I think it's doable.
Could I mention there are portions of Clint Rucker talking to you during one of the bond hearings?
We're gotta play that.
Yeah. Clint didn't look like he looked in that.
But I can get with Susanna and see if we can get something that's closer. Probably would be at odds on the jail issue. But the other ones, we can wait.
Okay.
You got to listen to this. I mean, there may be like 5 sentences in 5 minutes that Mr. McIver said. And other than that, you have Winnie saying, now all he has is his ring and his Bible and his jail cell. I mean, come on. Come on.
Well, I think some people were saying that when that story came out too, but, all right. But if there are 5 sentences that, that you don't have a valid legal objection to, that are relevant, that the state wants to put in, they just need to figure out a way to do that. It's not an argument to say, gosh, that's not very long, which wasn't your point, but hey, maybe there's a sentence. If Mr. McIver looks directly into the camera and says, I wasn't there, then perhaps the state ought to be able to play just that statement.
Right, and so what we can try to do tonight, when we're done today, is just at least narrow the universe of the 2 or 3 things that maybe we don't agree on. I'll get a redacted version and what we intend to tender for the court and Mr. Samuel, and hopefully we can be at a juncture we can admit it tomorrow.
Okay. Anything, Ms. Griffin, before we, thank you for being patient.
Of course.
Anything on the sausage is made. Before we bring the jury back in,
No, Your Honor.
okay, Ms. Clark Palmer, ready for the jury?
Yes.
Great, let's bring them in, please.
All jurors are present and accounted for, Judge.
Thank you, Deputy Murphy.
Please be seated.
How was lunch today? Particularly special, run of the mill? How many of you actually leave the building every once in a while to get lunch? All right, start dragging some of your colleagues out there fresh air. Tomorrow's supposed to be high 60s, low 70s, no excuse to stay in that windowless room for lunch. Unless that's what you want to do. It's your time. All right. Hopefully you recall we had Professor Radford on the stand. We completed her direct examination, and Ms. Clark Palmer is going to ask whatever she wants on cross-examination.
Whatever I want.
Within
I'm just kidding. I'm just kidding, guys. All right, good afternoon, Professor Radford.
Good afternoon.
So I would like to start asking you a few questions about sort of wills generically, and then specific questions about the ones you looked at in this case.
Okay.
You know that it's not uncommon for people to take some time to finalize their will and actually execute it, correct?
That's correct.
It's not something that people, maybe some people do, but as a general rule, it's not something that people kind of enjoy doing necessarily.
Right. I'm not sure I would say as a general rule. I think you're right that some people will do it right away, very deliberately, and some people will take some time to think it through.
Right. Because dealing with the will, you have to sort of contemplate your own mortality and what's going to happen when you're no longer on the earth, right?
That's correct.
Maybe not always a pleasant thing to think about for people.
That's correct.
Okay. So nothing unusual about the fact that someone may take months or years to make a change to their will, or even have a will executed at all, to draft a first will at all.
And I'm sorry, your question is there's nothing unusual about that?
Right.
Again, different people take different amounts of time. Right.
Okay. In a will, when somebody names an executor, that executor has duties and responsibilities that they have to carry out as part of their job as executor of the estate.
That's right, assuming they accept the job as executor.
All right? And if they accept the job, the law requires that they, for example, marshal the assets of the estate, right?
That's correct.
Okay. And in other words, they have to figure out, the deceased person, okay, what did they own that has some value to it, right?
What did they own and how did they own it? Yes.
Okay. And the reason you have to know that, part of the reason is because the executor also has to find out what are the debts that the deceased person might owe to other people or other companies, right?
That's correct.
And the law requires that debts be paid. It's not as if when you died, any debts you have are automatically extinguished by your death, right?
That's correct. Your estate still has to pay off your debts.
And the law sets forth different priorities in terms of who has to be paid. Debtors have to be paid in a certain order, right?
That's correct.
Okay. So when an executor has to marshal the assets of the estate, that may involve selling the property, selling the assets of the estate in order to generate cash or liquid funds that can be used to pay the estate's debt.
Right, I wouldn't phrase it exactly that way. The marshaling is actually just figuring out what's in the estate, but then you're correct that if there are debts that are owed and there is not sufficient cash to pay, then the executor might be required to sell some of those assets.
Okay. And I asked you if by a person dying, if that extinguishes any debt that they owe, and the answer is no.
Correct.
The same is true that if someone dies and they have loaned somebody else money, in other words, somebody else owes them money, just by the person dying doesn't mean that that loan is forgiven or extinguished necessarily, right?
Not necessarily right, so it would be then payable to the estate.
So for example, if I loaned you some money and I passed away and you still owed money on this loan, you may have to pay it back to my estate, right?
That's correct.
We'd have to look at the actual documents that reference the terms of the loan to see if maybe there's something in there about it being forgiven upon my death, right?
Right, that's exactly, you took the words out of my mouth, thank you.
All right, but other than that, without some kind of language in the loan documents, the borrower would still have to pay back on the loan.
Correct.
Okay. And people who are named, people can list out specific bequests in their will, right?
That's right.
And we saw in Diane's will where she made 3 specific bequests of money amounts to different people in her 2006 will.
Right, I don't know that Ms. Griffin and I went over that, but you may have already seen it, the jury may have already seen that, yes.
Okay. And so those people who are named in those bequests, do we call them beneficiaries of the will, or what are?
In Georgia, we call virtually anybody who's going to take under the will a beneficiary.
I'm sorry, could you say it again?
In Georgia, we call virtually anyone who's going to take under a will a beneficiary. They're called different things in different states.
Okay. Well, I'll use the term beneficiaries. And the executor has to, assuming the estate has enough assets, the executor has to pay those bequests that are listed in the will.
Correct. Now, we're assuming first the debts have been paid.
Okay.
Right.
Yes.
And then the executor's next job is basically to pay out, according to the will, to pay out the bequests.
Okay, so let me get that order right. So first thing, the executor's got to pay the debts that the estate owes.
Correct.
Which can include taxes.
Correct. Yes.
Like income taxes to the federal government.
That's right, or state taxes maybe.
Okay. And then debts that the estate may owe, right?
Correct.
And then after that, the executor is supposed to pay or satisfy monetary bequests that are made in the will.
Satisfy all bequests that are made in the will.
Assuming that there's enough money in the estate to pay those.
That's correct.
The executor has to do this. It's not, unless there's some language in the will, it's not optional for the executor to decide, well, I'm going to pay this person or not pay this person, right?
That's correct. It's not optional.
Okay. And those beneficiaries, if they don't get paid for some reason by the executor, do they have the ability to take some kind of legal action to force the executor to carry out his or her duties under the will?
Right. The executor basically has the first 6 months in which the executor doesn't have to respond to any request. But after that, then the executor's job is basically promptly to distribute the estate. So I would assume they would probably go to probate court. They also will be asked at some point, very likely by the executor, to discharge the executor. And if they haven't been paid, they probably will not agree to do that.
Okay, so let me just break that down just a little bit, because I forgot to ask, is one of the things the executor is supposed to do, are they supposed to notify the beneficiaries of the will?
Executors, there's not a specific requirement in the statute, but the basic requirement of the executor is to keep people reasonably informed as to what's going on. So as a practical matter, they are always notifying and talking with beneficiaries.
Okay. And then when the executor wants to go close out the estate with probate court, is the probate court going to say to the executor, okay, let me make sure that you've done everything you're supposed to do, you've paid the debts, you've paid the beneficiaries under the will? Does that happen?
Well, what will happen, and it not required, but what will happen is the executor will actually bring a petition to be discharged. And that would be either to be discharged from office only, or to be discharged from office and liability. And in order for the latter to occur, the executor will need to, again, have the beneficiaries sign off so that the probate court knows that the property's been distributed.
Okay. And so the beneficiaries have some protection or cause of action under the will to make sure that whatever bequest is made to them is carried out by the executor.
That's correct.
Okay.
How does it work if a will says $100 to person one, $100 to person two, $100 to person three, and it turns out there are only $200 in the estate? Does the executor get a hit? Does everyone get $66.67? How, whatever the math would be, 100.
But,
Forget about the math.
okay, please don't make me do the math, please. Well, basically, the first place the executor will look to pay off debts is the residue. So even if there's not money in the residue, if there are assets in the residue, then the executor would sell some of those assets to pay off those debts. But let's assume there's nothing left in the residue.
Just $200, that's
Okay,
it.
then there will be just a proportional division in terms of what these people get.
Okay.
You said it's proportional?
Proportional, right, to what they would have gotten under the will.
Okay.
If an executor looks at a will and says, well, I know that, the deceased person, there's something in the will that says I want to leave $50,000 to John Doe. Can the executor say, well, I know actually the deceased person didn't really like John Doe. In fact, the deceased person really liked Jane Doe. So I'm going to give the $50,000 to Jane Doe and not John Doe. Is the executor allowed to do that?
No, the executor would not be allowed to do that.
Okay. That's a legal requirement that prevents the executor from doing that, right?
And again, right, that's assuming that the will is very clear and we have somebody who meets the description of John Doe.
Okay. So a life estate. When somebody gets a life estate, what is a life estate?
It's basically just a temporary interest. And so let's say that I die with a will and give you a life estate in my house. That means that you, during your life, will have the ability to occupy my house, to live in my house, to obviously occupy and live in, to basically use the house for your benefit. But when you die, you don't have any control over where it goes. In my will, I would have said where the remainder will go after you die.
If I have a life estate in your house, am I free to sell your house while I'm alive?
Probably not. Sometimes it will depend upon how the will is phrased, and there are some cases that indicate that there, in some circumstances, you might be willing to sell your interest in the house, but the only thing the person who is buying will buy is your life estate. In other words, the person will not buy the house, but only whatever your interest is in the house, because that's all you have to sell.
Okay. So let me ask you specifically, in Diane's 2006 will, and if you need to reference it, just let us know, she leaves a life estate in the condominiums to her husband, Claude McIver, correct?
I recall that, yes.
Okay. And so, under the terms of Diane's will, is he free to sell the condominiums while he's alive?
Only thing that he owns is that life estate. So again, if somebody wants to buy his life estate, that person can buy his life estate in the condominiums. But the person who's buying will not be getting a fee simple in the condominiums.
Okay. And he is also not free in his will to leave the condominiums to anybody else because it wouldn't be part of his estate, correct?
Right. I mean, he can write whatever he wants in his will, but the bottom line is all he has is a life estate, so he has nothing to leave of those condominiums in his will.
He could write it down in his will, but
It
wouldn't
wouldn't
have
work.
any legal effect.
Right.
Okay.
All right, so
I wanted to ask you about States 451, this demonstrative, where, and this is my copy that I'm going to mark on here. One thing you looked at was, actually, just to be clear, you didn't look at an actual will that was drafted in 2011. You looked at an email that laid out some proposed things to be put into a will.
That's absolutely correct,
Okay.
yes.
All right, so defendant's draft of the will, defendant is Tex McIver, right? Right.
Correct.
Okay, so you looked at the email that it talked about changes he wanted to propose to his will, and he proposed passing the ranch, if he dies, to his wife Diane, correct?
Correct. Well, that's what the email says, yes.
That's what the email says. And then if Diane wasn't alive, he wanted it to go to Austin Schwall, right?
That's correct. Do you mind if I look at the email just to make sure I'm not remembering this incorrectly? Okay, so he says in the memo says, the farm passes to Diane, but if she's not alive, it passes into a trust for Austin.
All right. And Diane, at least according to that email, the proposed change was the same thing. She wanted the ranch to go to her spouse, and if her spouse was dead, then into a trust for Austin Schwall.
Right, it says the farm passes to Tex, but if he is not alive, it passes into a trust for Austin.
All right. You told us that one of the questions you were asked on the direct was, you know, can you leave property to whoever you want to leave it to? And I thought I heard you say, well, yes, but it also depends on how you own the property, right?
That's correct.
Okay. And I heard you say that if property is owned as joint tenants with rights of survivorship, it doesn't pass by the will, right?
That's correct.
Okay, so if it's joint tenants with rights of survivorship, is that called a non-probate estate, a non-probate asset?
That would be a non-probate asset, right?
Okay. So we have joint tenants with rights of survivorship. They're not right there. Okay, if you have joint tenants with rights of survivorship, that is a non-probate asset, right?
Correct.
Okay. All right. Should I say it does not pass through the will, or it doesn't become part of the estate?
Doesn't become part of the estate, right, would be a way to say it. It's also correct to say it does not pass through the will.
Can I say does not go to the estate? Is that okay?
It's not owned by the estate, yeah.
I've already written does not. So, okay.
How about does not pass through the will? Does
Okay,
that work?
I'll write that. So, as you said before, if we have a piece of property like the ranch, which is owned as joint tenants with rights of survivorship, Mr. McIver and Mrs. McIver could write whatever they wanted to about who should get the ranch when they died in their will, but legally what's going to happen is that the surviving spouse will become the sole owner, right?
That's absolutely right, yes.
And the ranch doesn't go through the estate at all.
Correct.
If either Diane McIver or Tex McIver wanted to, if they wanted to leave the ranch to Austin, for example, they would need to make a change in the way that the ranch was owned, correct?
They could do that. Alternatively, they could both agree to put both of their interests, and we'll just use that interest in the sense that we're talking about right now, into an irrevocable trust. That's a trust that can't be revoked. And that would mean that the property would stay in the trust, and they would make Austin the beneficiary of that trust when the second one died.
But you didn't look at anything that made any mention of either one of them creating an irrevocable trust.
You're correct. I did not.
And because the property was owned, because the ranch property was owned as joint tenants with rights of survivorship, and tell me if this is, if maybe you're not the right person to put this question to, does that mean that Mr. McIver is not free to transfer or sell his ownership in the ranch without the agreement of Diane McIver?
I'm not the right person to ask this question, I think. I think I know the answer, but I'd rather have an expert answer it for you.
Because is that a property question?
That's a real property question,
All
yes.
right. And you were also asked on direct about, I think the question was maybe whether Mr. McIver could change his will if he wanted to. And isn't it fair to say that people can change their wills whenever they want to?
That's correct. So again, so long as the person retains capacity, the person can change a will anytime up till death.
When you say retains capacity, what do you mean?
This is a concept in the law they call testamentary capacity, and it just means that you have enough mental acumen to understand that you're making a will, to understand who the property would go to if you didn't have a will, and to understand what disposition, what distribution you're setting out in your will.
Okay. A wife doesn't need her husband's permission to change your will.
That's correct.
Vice versa, a husband doesn't need his wife's permission to change his will.
That's correct.
You don't have to get the permission of any of the beneficiaries named in your will in order to change it.
That's correct.
Okay. So if Mr. McIver was free to change his will at any time, Diane McIver was free to change her will at any time, correct?
That's correct.
Diane can change her will at any time. Right.
Correct.
All right. Thank you, Professor.
Thank you very much.
Ms. Griffin, any follow-up for Professor Brad?
You mentioned an irrevocable trust. For the property to be placed in a trust, do both parties have to agree?
If they're placing their joint tenancy with right of survivorship, they would both be, yes, placing it into the trust. I suppose, I've never seen anybody do it, I suppose each one could put their own interest into a trust. I've just not seen that done.
So if you own a property as joint tenants with right to survivorship, and I want to put my interest into a trust, the other party doesn't have to, and then it will be just swap the owners, and the two would own it as joint tenants. Do you get what I'm saying? If I owned a property with you as joint tenants, and I wanted to put my interest into a trust for my daughter, if I passed, then you and her would own it as joint tenants? Is that how it would work?
Again, I think you probably want to ask your real property expert about that. My understanding would be that that possibly could sever the joint tenancy if it's an irrevocable trust, which means essentially you've sold it or you no longer have any interest in it.
Okay.
But again, I'm not an expert in that area.
And if an executor, if an estate has loans that are being owed to the estate, can the executor forgive the loans?
That is a question I do not know the answer to. Obviously, I think you'd want to look at the loan documents. I've just never examined that.
Okay. And if the estate holds the promissory note to a loan, or can the estate, does the estate have the same rights as the individual that had the note?
Right. In other words, if somebody owes me money and I have a promissory note and I die, right, then the executor is basically just standing in my shoes.
Okay.
Which, back just a second to your question about whether the executor can forgive, keep in mind again that the beneficiaries are going to be coming back at an executor if they feel that it was an inappropriate action in forgiving the loan. So the executor always has a fiduciary duty to those beneficiaries to work for their interests.
So if in my estate, I have a promissory note, and the executor is the one that owes the promissory, that owes the estate the money, can the executor foreclose on his own interest?
In his capacity as executor, he could, I believe so. Mm-hmm.
Does he have to?
Well, foreclosure is a little bit different than than requiring that the loan be paid. For example, if the loan was due to be paid out over a period of time, I don't think the executor can just decide he's going to foreclose on it.
If the estate could foreclose, could he?
Yes.
And did he have to?
again, we'd have to look at what the terms of the loan are.
I have another question.
Jurors, questions for Professor Radford? Before you try to stump her with that math, it was $66.
67 or 66 cents?
Well, repeating, I rounded it up. Thank you. Professor, based on Ms. McIver's 2006 will
Correct.
and Mr. McIver's 2016 will, does Austin Schwall, the name that you may have seen in one of those two documents, have any rights to the ranch or farm property that you may have read about? If you need to consult the documents, that's fine. This isn't a pop quiz.
Okay, right, thank you. Under Diane McIver's will, basically, again, assuming that property was owned as joint tenants with right of survivorship, even though there was some, under her, the 2006 will, Austin's not even mentioned. So basically, the property, when she dies, becomes the property of Tex McIver. Now, that's assuming that we're following through this course of events. So that means that Tex McIver is now the sole owner of the property. And so when Tex McIver dies, after that $500,000 goes to his son Robert, then Austin gets the rest or residue of the estate, which would mean that he would get that property. And that's why I said it was a little confusing. It sounds like he would get it, but it's in trust. So it's in trust till he reaches a certain age. But essentially, we didn't really go into that in this will, but the way the trust was set up, the beneficiary could ask to have everything in the trust given to him at age 25.
How and when, if there's a time frame surrounding it, can a will be challenged?
The basic approach, again, I don't know if you recall that I mentioned that when the executor or whomever takes the will to be probated, the executor is required to notify people who would take if this will were not admitted to probate. Those people have up until the date of the admission into probate to challenge the will. Now, unfortunately, some people don't know that. They think that they get the notice and they have 30, 90, 80 days. That's not really true. They just have to come into the court and say, I'm challenging this will before it's admitted to probate. Now, was the second question, what were the grounds?
No, it was just how and when.
Okay.
So I think you addressed it.
Good. Did that help? Okay.
Okay, all right. Any follow-up, Ms. Griffin?
No.
Ms. Clark-Paul?
No, Your Honor.
Thank you so much for spending time with us. You are free to go.
I appreciate it. Thank you.
Next witness.
They call Carlton Morris.
All right, so Carlton Morse is being called subject to concerns or issues that the defense raised previously, and I assume you're renewing all those bases for concern.
Yes.
They are renewed.
Raise your right hand. Do you swear and affirm that the testimony you should give the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I will.
Yes, sir. If you will, have a seat.
Thank you.
Get as close to the mic as you can.
All right.
For the purposes of the court's record, please state and spell your name.
My name is Carlton Harold Morse, Jr., Carlton Harold Morse, Period. Thank you, sir.
Good afternoon, Mr. Morris.
Good afternoon.
Where are you currently employed?
I'm employed with Luter, Larkin and Hunter, LLP.
And is that a law firm?
It is a law firm.
And what type of law do you practice?
My practice concentrates in real estate. I do real estate closings. I help people with the purchase and sale of homes with real property and different items concerning investments.
Okay. And what is your role or what is your title at the law firm?
I'm an attorney, managing attorney at their Stockbridge office, and in that role, I examine titles, I issue title insurance, I do the things for conducting real estate closings.
And if you could, please tell us a little bit about your background in education.
I'm originally from Sparta, Georgia, in East Central Georgia. I grew up in Fort Valley. I went to Yale College, Yale University, graduated in 1975. I attended Duke University School of Law in 1978. I took a year off and then came here to practice, and have been practicing here since 1979.
And since 1979, has the focus of your practice been real estate?
Yes, it has. First at the U.S. Department of Housing and Urban Development in their litigation section, and also worked with their Georgia Programs branch doing real estate-related closings for apartment complexes. Then I went into private practice in 1985 and have been in private practice since then. Ended up with a firm that bore my name, Shuping, Morris & Ross. And
I'm sorry, say it again.
Shuping, S-H-U-P-I-N-G, Morse, M-O-R-S-E, and Ross, R-O-S-S. And practiced there for 23 years. And then sold that practice and took a little time off, and then went to work with Luter, Larkin, and Hunter.
And do you belong to any professional organization?
Yes, I do. I am a member of the State Bar of Georgia. I'm a member of the Gate City Bar Association. I'm a member of the Georgia Real Estate Closing Attorneys Association. I'm a past member of several organizations. And I've been
What was that last organization? Trying to hear the last one.
Georgia Real Estate Closing Attorneys Association. My apologies.
It's okay, Mr. Morse, we've got a weird setup where the court reporter can't see the witness. This is the only courtroom I know of in the courthouse where they're hidden. The most important person from the court reporter is the witness, and that's who the architect is hiding from the court reporter. So it's good you're not telling me you're an architect.
And have you ever presented at any conferences or seminars?
Yes, I have done several presentations to the annual Real Estate Law Institute for the Institute of Continuing Legal Education. I've done presentations for the Real Property Law section. I've done for private organizations that put on legal seminars throughout Metro Atlanta and the state of Georgia.
Okay. And approximately how many real estate closings have you done?
It's hard to say. I estimate 6,500 closings that I've done personally, conducted personally, and I've worked on many more, and I've done title examinations for more than 10,000 transactions.
Okay. Have you ever testified before in the courts of Georgia as an expert in the field of real estate and property?
Yes, I have, and there are three transactions that or three cases that I can think of, but they were all in the civil realm, and they involve boundary line disputes, real estate commission transactions, and an accounting transaction involving disputing investors.
Okay. And was that in Fulton County, DeKalb County, any other county?
All in Fulton County.
Okay. Your Honor, at this time, the state tenders Mr. Morris as an expert in the field of real estate and property law. No objection.
Okay, Mr. Morse, you are hereby qualified for the purposes of this criminal proceeding as an expert in the field of real estate and property law.
Thank you.
You're welcome.
In preparation for your testimony today, did you review any documents related to the ownership of 603 P Ridge, as we've been calling it here in trial, the ranch?
Yes, I did. It carries the street address of 603 P Ridge Road, Eatonton, Georgia.
Okay.
Yes.
And did you perform a title search on this property?
Yes, my firm did do a title examination. It was an examination that went back in time to 1945, so we have more than a 70-year chain of title for the property there on Pea Ridge Road.
Okay. And what is the purpose of performing a title examination?
Principal purpose is to determine who the owners of the property are. When you do a title exam, a lot's going to depend on what the purpose of the title exam is. Is it being done for a purchase and sale transaction? Is it being done to find out what the dimensions of the property are? Sometimes it's to determine what kind of mortgages or liens are on the property pre-existing. You have all of those that can be determined by doing a title examination.
Okay. And after did you also review some promissory notes and documents that were given to you by the state?
Yes, I did.
I'm going to show you State's Exhibit number 427. And this is a promissory note dated March 1st, 2005 for $750,000. Did you review this promissory note?
Yes, I have reviewed that before.
Okay. I'm going to show you State's Exhibit number 428. It's a note secured by real estate dated December 23rd, 2011 in an amount of $350,000. Did you review this promissory note?
Yes, I have had an opportunity to review that.
Okay. I'm going to show you what's been introduced as State's Exhibit number 452. And this is called a second priority deed to secure debt and security agreement. Did you have a chance to review that?
Yes, I did.
I'm going to show you what's been introduced as State's Exhibit number 429. And this is a renewal promissory note dated December 22nd, 2014 in the amount of $350,000.
Could you slide it up to
Yep.
or down?
Down.
Is there a second page?
Yep, I can bring it up to you.
Yes. Yes, I have reviewed this.
Okay. And did you prepare a report of your findings after you reviewed the documents that we provided and your title search?
Yes, I did.
I'm going to show you what's been on the
This is an affidavit that I prepared after I conducted the title examination for the property.
And if you could look at that, let me know if there appears to be any alterations or deletions to the document.
There don't appear to be any alterations or modifications.
Okay, Your Honor, permission to introduce State's Exhibit number 270.
Any objection to State's 270?
I mean, just the same objection as with Professor Radford. I don't think it should be published or go back to the jury.
Were you planning on publishing it?
Nope.
Okay, it will be made part of the record, and we'll work through at a later time what, if any part of it should go back to the jury. 270 is it?
And in preparation for your testimony today, did we create a demonstrative for you to use to aid in your testimony?
Yes, we did.
I'm going to show you what's been marked as State's Exhibit number 455. Recognize that?
Yes, I did.
And what is it?
It is a chart that shows dates, ownership status, and existing mortgages and liens on the property at 603 Pea Ridge Road in Eatonton.
Does that accurately reflect the chart that we created?
Yes, it does.
And do you adopt this demonstrative?
Yes.
Your Honor, permission to publish the demonstrative as an aid to assist in the testimony of Mr. Morris. No objection.
It is admitted as a demonstrative aid.
And we have a blow-up of then Mr. Abadi said for it, but I'll move on until he gets his set up.
Okay, thank you.
And Mr. Morris, could you please describe the property at 603 Pea Ridge, like number of acres and things like that?
Yes, there are recorded plats for the property, and in those recorded plats, it shows 3 tracts of land. I'll call them as Tract A, tract of land that's 81.38 acres. There's a second tract of land that has the house on it that originally, when it was purchased in 1996 by the defendant, it was 4.08 acres. And then there's another tract in the southeast corner of the property that is a 1-acre tract that was purchased from a Winslet family. So altogether, a little bit more than 86 acres.
Okay, let me show you state's exhibits number 435 and 436. Did you pull these when you did your title search?
Yes, these were made evident with the title examination, and these are very familiar to me.
Do there appear to be any alterations or deletions to those items? To item 435 or 436?
No, these are exactly what is recorded at the Putnam County Courthouse and which appear on the Georgia Superior Court Clerk's Authority website.
Permission to introduce state's exhibits 435 and 436 and publish.
So 435 is in, those are cell record or call record with Mr. Hudson. 436 was one of the Mr. Sprinkle images, the blow up. So your number, we'll need to renumber those. 453 and 454 are available if you want to use those. Or 1,000.
1 second.
Okay, Your Honor, we're changing it to 456 and 457.
Okay. Any objection to 456 and 457?
No.
They're admitted.
I'm going to show you state's exhibit number 456 first. And if you could, please describe what we're looking at here.
Okay, what you're looking at on the right-hand side of the screen is P Ridge Road. There is a line leading from P Ridge Road to a square.
You can touch the monitor.
All right. There's this is a road leading up to a.
Push your finger. I want to see if it's supposed to make up there. See that? That's you.
Okay. And there's the tract B is known as the 4.08 acre tract. A larger tract is the tract that goes around that. And then in the bottom corner here, that was a tract that was purchased in 2001.
Okay. So based upon your title search, when did the defendant purchase this property?
Purchased this property on November 1st, 1996.
Okay. And when he purchased this property in 1996, was he the sole owner of the property?
That is correct.
And what is that status called?
That's called fee simple. Sometimes we call it fee simple absolute title. That's the type of title where you own the property as a total freehold interest. By total freehold interest, I mean you have absolute control of that property. You can lease it if you wish to. You can sell it if you wish to. You can pledge it on mortgages if you wish to. You have full alienability. You can leave the property to whoever you would like. There are other estates that people get that are less than fee simple. They may get a property for their lifetime, and after their lifetime it goes to someone else. That's what we in the industry call a life estate interest. Sometimes people...
I'm going to stop you there only because if we need to learn about some of these other estates or formats, I'll bet you Ms. Griffin or one of the defense attorneys will ask you.
Okay, thank you very much.
You were on a roll, but we're going to...
Okay, so he owned that property in fee simple in 1996.
Yes.
And that meant he can do whatever he wanted to do with it. He could leave it to whoever he wanted to if he drafted a will.
That is correct.
Okay. And when in time was the first promissory note that you reviewed? Do you remember?
When in time was the first promissory note?
I'm going to show you this one from March 1st, 2005. Was there one before that?
No, there was not one before that. The reason I hesitated is that I've seen a lot of security deeds for prior transactions, and many times information from those security deeds, you might think that they were a note, but this is the first note that I saw.
Okay. And this promissory note for $750,000, is it secured by any interest in the ranch?
This is an unsecured note. When I did the title examination, I did not pick up a security deed that referenced an indebtedness dated March 1st, 2005.
Okay. That was March 1st of 2005. Based upon your preparation here, when did the defendant and Ms. McIver get married?
I only have hearsay sometime in...
When did you learn that they got married?
When did I learn that they got married? When did I learn?
What month and year did...
November 2005.
Okay. And did you find in your title search a time when he gave her a deed to ownership interest in the property?
Yes, I did.
And when was that?
That was on November 5th, 2005.
And when he gave her the deed to give her interest into the property, is this a requirement that he had to do because they got married?
There is no requirement of a deed when you own fee simple title to property.
So he could have kept the property in fee simple because he owned it before they got married?
Yes, that is correct.
Okay. So November 7th, he gives her an interest in the property as, could you explain what type of ownership status they had?
Yes, I did have a chance to review the deed. It conveyed the title from himself in his individual capacity to himself and Mrs. McIver as joint tenants with right of survivorship.
And what does that mean?
All right, what that means is that they hold the property together. They each have an undivided 1/2 interest in the property. They each have full possession of the property. However, at the point that one of them passes, the survivor gets the title to the property automatically. The person who dies, their interest is cut off immediately, and the interest remains in the survivor.
Okay. And they owned it as in that status from 2005.
Yes,
2005.
November 2005.
And in December 22nd, 2014 is, I'm sorry. Let me show you State's Exhibit number 428. On December 23rd, 2011, there's a note secured by real estate.
Yes, that is the title to the instrument. It's for $350,000 at 5.25% interest.
And what is the amount?
$350,000.
And who are the parties to this note?
Clay Management Company is the lender, and the borrower is Claude L. McIver III.
Okay. And based upon your title search and your preparation for testimony today, did you determine who Clay Management Company belonged to?
Yes, I reviewed the Secretary of State's website, and when this document was executed, Diane Smith McIver was the CEO, CFO, and Secretary. She was all of the officers of this corporation.
So she was the only owner of Clay Management Company?
Yes, from what appears at the Secretary of State's office, yes.
Okay. And it says that it was secured by real estate. That's what it's the title of it?
Yes, that is correct.
And what real estate was secured by this note?
The real estate that was on P Ridge Road was secured by that, and the legal description to it mimicked the legal description from the 1996 deed. So all of that property that I pointed to you earlier on the P Ridge Road, all of that property was included.
So that would be from the large...
That would be
all of this
all of that, and the tract in here,
and this.
right, and the tract right here.
Okay, so this entire tract of land was secured by that promissory note in 2011.
That is correct.
And what was the due date on this promissory note?
December 23rd, 2014.
Okay. And in this promissory note that you reviewed, did they have terms for late payments? Any provisions for late payments or default?
Yes, upon default of the property, the holder could invoke any remedies under the security deed, which would include a foreclosure of the property.
Okay, and when was that note due?
This note was due December 23rd, 2014.
Okay. And when you say that the note was secured by real estate, what does secured mean?
That means the property is collateral. It is the property that stands in for those instances when there is a default on the note.
Okay. And I'm going to show you what's been introduced to State's Exhibit number 147-20. And if you could, please read me the date that is from Harold Hudson to Tex McIver and Diane McIver.
The date is Friday, July 1st, 2011.
Okay. So it's already been introduced. So this email that was sent from Harold Hudson to the defendant and Diane, was this email before or after she gave him the promissory note from December 23rd, 2011? The promissory note was done in December of 2011. Based on this email occurred before that. Before the promissory note?
Yes, this email was before the promissory note.
Okay. I'm going to show you State's Exhibit number 429, which is a renewal promissory note. And did you have a chance to review this note?
Yes, I did.
And could you please explain what this note does with relation to the first note from December 23rd of 2011?
This is a renewal note. It was done. It was done at the same time there was a security deed that was filed of record, and it was done as part of a transaction where Brand Mortgage Company did refinancing of the property, advanced $417,000, and Brand Mortgage and many of the first mortgage lenders want to be in a first mortgage position. The loan to claim management would have been in a first mortgage position unless Clay releases his interest or subordinates his interest. And this was part of that subordination process. Instead of paying off the $350,000, they released part of the property from that 2011 loan and then went ahead and did a renewal promissory note and then filed a new second position security deed.
Okay, so they were getting a loan. She originally had first mortgage on this property, and then they were getting a loan from Brand Bank for $417,000, and they had to become second mortgage. Is that what you're saying?
Not quite. The 2011 mortgage was a subordinate mortgage at that time as well. It was subordinate to a previous mortgage to CWA mortgage. So these mortgages to claim management were always in a second position.
Okay. So in this renewal, what was the due date on this renewal?
The due date was December 1st, 2017. I'm sorry, December 21st, 2017.
Or when else?
Or there was a demand feature, and with the demand, or within 90 days of demand, whichever first occurs. So there could either be a 90-day demand put in after December 22nd, 2014 that would bring the note due or mature, or at the latest, December 21st, 2017.
So she could have demanded payment before December 21st, 2017.
That is correct.
So if she demanded payment before December 21st, 2017, if she exercised the 90-day demand, what would be the process of that?
when we say she, claim management.
Claim management.
Right, claim management would go ahead and send a demand letter, and that would total the 90 days. After the 90 days, if payment wasn't made, then claim management could accelerate the debt and proceed with non-judicial foreclosure.
And what does non-judicial foreclosure mean?
In common parlance, we talk about foreclosing on a property. Here in Georgia, you can do a judicial foreclosure or a non-judicial foreclosure. Most are non-judicial, and in that process, what happens is that a notice is sent to the debtor saying the amounts are due. A copy of the foreclosure ad is sent to the debtor, and then there's advertisements once a week for 4 consecutive weeks prior to the foreclosure date. Non-judicial foreclosures always occur on the first Tuesday of the month. So the previous month there will be the advertisements, and then on the first Tuesday on the courthouse steps, foreclosures occur. And that's where the property is put out to the public to be bid on.
And if claim management put the property out to be bid upon, can they purchase it?
But claim management will start the bidding on the property, and if there are no other bidders that are higher than that initial bid, claim management would be the owner of the property.
And if, could claim management do this even though they were in a second position?
Yes, but when they do it in the second position, there's still the first position mortgage, and claim management would have to begin making the payments on the first mortgage, or otherwise their second position would be wiped out if the first mortgage holder foreclosed.
Okay, so claim management will own the property subject to the first mortgage, or she would just have to start making payments on the first mortgage?
That is correct.
Okay. And this 90-day demand that's evidenced in this renewal promissory note, was it in the promissory note from 2011?
I did not see that provision in the 2011 promissory note.
Okay. And if you look at the second paragraph of this promissory note, if you read the last sentence, what does it say?
Debtor has requested that said promissory note be renewed.
Okay. And so you said also that when they renewed the promissory note, did the second promissory note affect the entire property at 603 P Ridge?
The notes are promises to pay. What is affected is the property that's pledged, and the property that was pledged on the renewed note is a different configuration. It's based on a plat that's recorded at Plat Book 33, page 103A. All right.
The plat reference.
The plat reference is Plat Book 33, page 103A.
Okay, I'm going to show you State's Exhibit number 457. And what are we looking at here?
You're looking at the plat that I'm referring to. When the renewal note was done, the portion that is identified as Tract 1 is the security for that renewal note.
Okay. So we have the note from 2011 that was due on December 22nd of 2014. Is that we have that promissory, that note?
Yes.
And when they renewed the note in 2014, they only renewed it as to this part?
That is correct.
So what happens to the note, the property that's secured by the 2011 note?
They did a release of that property as well, and my experience in training tell me that that release was done because Brand Mortgage was doing a new first mortgage on this Tract 1. So that is the reason why the renewal note is concerning that Tract 1. Tract 2 is still covered from this one. It's still covered by the security deed from that first promissory note and security deed that were done in December of 2011.
Okay, so the promissory note from 2011 was due on December 22nd, 2014.
Yes,
And that was for $350,000.
yes,
And that was secured by the entire ranch.
yes.
So when they renewed the promissory note in 2014, it only encompassed 11.49 acres.
From what I see and from what's recorded at the courthouse, that is correct.
So of the 80, how many acres you said?
There were 85.46 acres, yes.
Okay, so you have 85 minus the 11, so that's about...
73, 74, somewhere in that range.
So was the other 73, 74 acres subject to foreclosure from the 2011 note?
Yes,
So if the $350,000, since it hadn't been paid, she could foreclose on the remaining property at any time?
that is correct. I might add that there was an assignment later, and the assignment was just of the Tract 1 parcel.
Okay.
And security deed. They secured the Tract 1 parcel.
And for the remaining 70 acres that were not renewed under the new promissory note, does she have to do the 90-day notice for that property surrounding the 11.49 acres?
To do a non-judicial foreclosure, you always have to go through the notice provisions. You have to send a notice to the debtor, you have to advertise, and then you have to go to the courthouse steps.
Okay. So could she foreclose on both parcels of property at the same time?
If they were in default, yes.
Now, was this 70-something acres outside the 11.49 acres, would that be in default?
Depending on the facts, yes. When you say would they be in default, if the terms of the note had not been met, they would be in default.
So if he hadn't paid the $350,000 by December 22nd, 2014, would he be in default on the 70-something acres surrounding the 11.49?
Yes.
Okay. And on this promissory note, does it require for him to be delinquent in payment for her to foreclose?
There is a demand feature. It doesn't have to be the terms. That there is a demand feature, yes.
And what does that mean?
That means that upon a request by the holder, clay management, payment would become due.
Does she have to wait until he's 10 payments behind, 5 payments behind, or can
No.
clay management do it whenever they feel like it?
No, they can't. They don't have to wait. No.
So if he is current on his payments, they can still do a 90-day demand?
Yes.
So if clay management forecloses on the property, what would become the status of ownership for the property with Diane McIver?
At the point of foreclosure, clay management would own an undivided 1/2 interest in the property. The joint tenancy would be severed, and as a consequence, clay management would own a 1/2 interest, and Diane Smith McIver would own 1/2 interest.
So it would be a joint tenancy created with clay management, which is owned solely by Diane, and Diane McIver.
It would not be a joint tenancy. It would be a tenancy in common,
Okay.
which means they each own an undivided 1/2 interest. Now, because Diane Smith McIver is the owner of clay management, or was, she could deed clay management's interest to herself and vest title in herself totally.
Okay. So if she foreclosed on the property and she deeded her interest from clay management to herself, would she own it in fee simple?
Yes, she would.
And if she owned it in fee simple, could she devise that property to anyone she wanted to in her will?
Yes, she could.
If she wanted to leave that property to Austin Schwall after she foreclosed, could she?
Yes, she could.
Now I want to ask you, we were talking about the foreclosure and joint tenants with rights of survivorship. Do you know about the Slayer statute?
The Slayer statute, yes, I do. I am familiar with the Slayer statute.
And if she had foreclosed before she passed, could the defendant inherit the property?
If she had foreclosed.
If she owned the property in fee simple before she... I'm going to show you what's the market state exhibit number 454. I'm going to show you what's the market states exhibit number 454. Excuse me. Would that aid you in your testimony with explaining how the Slayer statute would work?
Mr. Morris, are you familiar enough with the statute that Ms. Griffin is asking you about that you could apply it to a fact pattern?
Yes.
Okay.
Yes. All right. So your question again?
Would this help you, would this aid you in explaining the Slayer statute to the jury?
Yes.
I have an objection.
Okay. Okay.
So, if you could please just explain how the Slayer statute works generally.
Generally, if someone commits a felonious act, he can't benefit from the felonious act. So, if there was a murder committed by one, the assailant couldn't collect from the estate of the victim. Is the basic public policy behind the Slayer statute.
Okay. So the Slayer, if Diane McIver foreclosed on the ranch, and she owned the ranch in fee simple, and upon her death, the ranch would go into her estate. Would the Slayer statute control her estate if she leaves the ranch in a will?
Yes.
Okay. If she had never foreclosed on the ranch and she died, and they owned the property as joint tenants with rights to survivorship, does the Slayer statute apply?
There's a question concerning that. I think when the Slayer statute was issued, it was done as part of the probate and estates, and it really is looking for property that went from the decedent into the decedent's estate. But with joint tenants with right of survivorship, the interest terminates right at the person's death, so that it never gets into the decedent's estate. It terminates before going to the estate. So it can't be devised by will. It can't be left to others. Their interest terminates at the point of death, and the survivor gets the title to the property. Whether sometimes joint tenancies have 3 survivors or 4 survivors. However many survivors, they get the remaining title. The one of the decedent terminates immediately.
Okay. So if she did not foreclose, the ranch wouldn't pass to her will, and the Slayer statute would not apply, meaning that whoever owns it with her could still inherit the ranch.
That is my understanding. Yes.
We talked earlier about late payments and default. What exactly do you mean by default?
Default. Mortgages have events of default. The one that most of us pay attention to is making the mortgage payments. There are other making mortgage payments. All right, if the payments due aren't paid, that is an event of default. There are other events of default that can occur. If you have insurance on the property and the lender requires you to have insurance and the insurance elapses, that's an event of default. You have you have other events of default. If you don't maintain the property and the lender or the holder feels like the property is diminishing in value, that would be an event of default. So that's why we use that general language, event of default. The principal one is non-payment.
Okay. And again, for her to foreclose, he did not have to be in default or have to have any payments. In order for her to, I'm sorry, in order for her to foreclose, he did not have to be in default or miss any payments.
On the renewal note, that is true because it had a demand feature.
And I have no question.
Okay. Ms. Clark Palmer.
Thank you, Judge. Good afternoon.
Good afternoon.
I'm Amanda Clark Palmer. We've spoken on the phone before, but it's nice to meet you.
It's a pleasure to meet you as well.
Thank you. I have a few questions. I guess let me ask you about, let me start by asking you about different types of notes, the two different types of notes we looked at. One, which was States 427, is a promissory note, which is different from a note secured by real estate, correct? Well, let me ask this question.
A promissory note is a promissory note, whether it's secured by real estate or not. It's still a promise to repay.
This promissory note, the one from March 1st, 2005, is not secured by real estate.
That is correct. It is
Okay.
not
All right.
secured.
So unlike States 428, which is secured by real estate, right?
That is correct.
All right. When you have a note secured by real estate, are there things that the person who's lending the money, the person who is the note holder, are there things that they can do or have to do in order to protect their interest in that property related to the note? Like, do they file something with the clerk's office?
Yes, they file a security deed, or sometimes it's called a deed to secure debt. In layman's language, it's the mortgage.
Okay. And what does, filing it with the clerk's office and the deed to secure debt, how does that protect the person who's the note holder or the lender?
All right. It protects them by putting the world on notice that they have a first lien interest or a lien interest in the property, so that if the owner of the property tried to sell the property to someone else, they couldn't sell it without paying off that existing mortgage.
Okay. And when you want to go file a security deed, or which one gets filed? Do you file the note with the clerk's office, or you file the security deed?
You file the security deed.
All right. So is there a fee or a tax or anything that is associated with notes secured by real estate that are of a certain length in time?
Yes, there is.
Okay, so what is that?
All right. With the security deed, if it's a long-term note, which means that it's 3 years or longer, there's a tax of $1.50 per 500. We in the industry just translate that as $3 per thousand.
$3. Okay.
Okay.
And does it, so is it 3 years or longer than 3 years?
It's 3 years or longer.
All right. Well, so in this case, for this note, would this one have been subject to that, what's that tax called?
It's called an intangibles tax.
Would this note have been subject to
Intangibles tax. INTANGIBLES.
Would this note have been subject to that tax? Can you tell by looking at the note?
The note, yes, because that is three years. So yes, that would be subject to the tax, the intangibles tax.
And you said it was long-term notes have to be subject to this recording tax.
That is correct.
Okay. And I want to show you something. This is written down in the statute, right?
Yes.
You're not just
Dreaming.
dreaming this up. Okay.
I can get up.
All right. This statute that refers to the what the definition of a long-term note is. Does the statute say that a long-term note is one where the principal of the note falls due more than 3 years from the date of the note? Would looking at the statute refresh your recollection?
Yes, it would.
I don't have a printed copy. Don't read it out loud.
I see the language that says, or from the date of any instrument executed to secure the day, 3 years from the date of the note, or from the date
You don't
of
need to
any
take down what he's saying right now.
So the recording tax is due if the note is for more than 3 years?
It is for more than 3 years, and I can just tell you industry practices that it's 3 years or more than 3 years. It's 3 years from the date that we traditionally do. If it's within the 3 years, there's no intangibles tax. And usually within 3 years means 1 day less than 3 years.
Okay, all right, got it. So if this had said December 22nd, 2014,
2014.
then it would have been within 3 years.
Yes.
I'm with you. Okay. And this note that was secured by real estate in December 23rd, 2011, had the security deed that went with it that got filed in the clerk's office, correct?
That is correct.
Okay. And then we move forward to the December 2014 note that we've already looked at, which was states 429. And you talked a little bit in your direct testimony about the foreclosure process.
Yes.
And it's fair to describe it as a process, correct?
That is fair.
Okay. You don't just to go, show up at the property and say, I'm foreclosing and take ownership of the property that day, correct?
No, you don't.
All right. Part of the process is to give the borrower notice that the foreclosure process is going to begin, right?
That is correct.
Typically, borrowers are given a chance to prevent foreclosure.
Yes. Cure the default is the term we use.
Okay, cure the default. And maybe they can cure the default by negotiating with the lender about catching up on payments that are owed. That might be one way they could try to cure the default.
Yes.
They could try to secure different financing, right?
Yes.
Typically, loans on real estate are usually, well, is it fair to say that typically loans that are secured by real estate are usually for the value of the real estate or less than the value of the real estate?
If the lender is doing asset-based lending, the answer to your question is yes.
Okay.
Some lenders are not doing asset-based lending.
Okay.
Sometimes they are getting additional collateral for other reasons.
All right, fair enough.
But give an additional.
Collateral for other reasons.
So it's possible that somebody may own a piece of property that, let's just say, is worth $1 million, okay? And if they have a note secured by that property for $350,000, and the person who holds that note wants to foreclose on it, they have some equity in their property that they can use to try and go get a loan from a different lender, correct?
That is correct.
Okay. And that may be one way they could try to cure the default with the note holder, right?
Yes.
All right. And I think you and I talked before about what happens when you've got somebody who wants to foreclose on a property where there is equity in the property above and beyond what the value of the loan is.
Yes, we had that conversation.
Right. So what happens if there is a foreclosure on property where there is equity in property above and beyond the value of that loan? What happens to that excess equity? How does it get distributed?
Okay. when there's a foreclosure, the bidding starts at the level that the lender indicates is their indebtedness due. And that would be the principal balance of the loan at that time, any interest that's accrued, any collection charges, their costs for doing the advertisement, their attorney's fees. So say, for example, if the loan balance was $350,000, but with interest unpaid and collection costs, it was $365,000. The lender would start the bidding at $365,000, and that would be the initial bid. Now, if there's a bidder there, and that bidder bids $1 over, then that bidder gets the property, and the lender gets to be reimbursed for their foreclosure and their expenses. That additional equity is just that equity out there. Now, if there's bidding and the bidding goes over $1, somebody else comes back and they bid it up. And say, for example, they bid it up to $400,000. Well, the difference between the $365,000 in my example and that $400,000 would go to the holder of the first mortgage, because there's a first mortgage above the clay management loan. And then if you take care, if the bidding price was higher, say to $1 million, then...
But we can explore that if that becomes relevant, but I think you have to understand if it got above what the note amount was.
Well,
Okay, all right, go ahead.
were you almost done? Because I was interested in the last part of the answer that we were getting to after we had paid
Right.
the first mortgage. And the
Right, and after you pay the first mortgage, any surplus goes to the record title holders. Right, and the record title holders would be the defendant and Diane.
Okay. In this case, fair to say that typically one way that the value of the property may be determined is through an appraisal, right?
Value can be determined, but when a foreclosure is done, it's rare for the lender to do an appraisal unless the lender knows that at foreclosure they aren't going to get the amount that they are due. So they'll go through a process to get the appraisal done so that they can then do a confirmation of the sale and then proceed with the deficiency judgment against the debtor.
In this case, did you see any documents that were an appraisal of the 80-something acres at Pea Ridge Road in Eatonton, Georgia?
I have not seen any appraisals of the property.
Did you see any documents that set forth what the value of 603 Pea Ridge Road, that property is?
When I'm doing title examinations, I'm really determining title to property. I'm not really looking at for valuations of property. When we do those title examinations, there will be the taxes. We will review the taxes. Many times the tax assessor and the tax commissioner will have valuations on their tax records. But again, we're doing, our task is to do the title examination. So valuation really doesn't enter into what we give as an attorney's opinion concerning title.
Okay, so for your purposes here, talking to the jury today, you weren't focused on what's the value of the ranch?
No.
All right, you were focused on just who owns it, when and how?
When and how, if there are any mortgages, where there are any liens, where the taxes paid, items like that.
All right, and so we've got the one note that Diane McIver holds for $350,000 that's secured by this property, correct?
That is correct.
And then you told us about, there was the other mortgage that Brand Bank holds.
Brand Mortgage.
Brand Mortgage holds as to a tract one.
Yes, that's to tract one, yes.
Okay.
The 11.94 acres, yes.
And the value of that mortgage is?
$417,000 was the initial unpaid principal balance. On the deed records, you can't tell how much has been paid down since then.
All right, but what the value of the property is altogether is just not part of what you looked at?
That is correct.
Okay. Do you have any way to tell from the documents you looked at whether Brand Mortgage was engaged in asset-based lending when they made that $417,000 loan?
From my experience in the industry, yes, they're an asset-based lender.
Okay, which means that their loan would have been, they would not have loaned money for more than what the property would have been worth.
That is correct.
All right.
At least at the time they loaned it.
Right.
Very good.
Okay. Lived through situations.
Yes, yes.
Didn't go well for asset-based loan.
And just to kind of take that one step further, if you don't know the value of the property, we can't determine what equity Diane McIver or Mr. McIver had in the property.
That is correct. Not from my title examination, you cannot.
I think you touched on this in your direct, and I want to make sure that I heard you clearly. When two people own a piece of property as joint tenants with rights of survivorship, well, and just so deal with Tex and Diane in this case, when they owned this ranch as joint tenants with rights of survivorship, was Tex free to sell the ranch without Diane's permission?
No,
Okay. And same for her, she couldn't sell the ranch without his permission?
that is correct. She could not.
Okay. Could he transfer his interest in the ranch to somebody else without her permission?
Yes, he could.
Okay, so tell, what could he do?
All right. Under the joint tenancy statute, you can sever the joint tenancy, and you can convey your lifetime interest in the property to someone else. At the moment that you do that, the rights to the property are transferred into what's called tenancy in common. They each will, whoever he deeds the property to, would have an undivided one-half interest, and Diane would have an undivided one-half interest.
And Mr. McIver could do that without Diane McIver's permission?
He could do that without Diane McIver's permission.
And she could do that without his permission?
That is correct.
Okay. You were asked questions about, what would happen if Ms. McIver foreclosed on this note that she had.
Yes.
Did you ever see any document that referenced a desire by Ms. McIver to foreclose on this note?
I did not.
All right. Did you ever see any document that showed Ms. McIver took any steps to foreclose on this note?
I did not.
Okay. Thank you, Judge. Those are my questions.
Ms. Griffin, redirect.
When you reviewed the documents that we gave to you, Ms. Clark Palmer was talking about the defendant perhaps trying to cure a default, or someone could try to cure a default. Did you review any documents where the defendant applied for a loan in February 2017?
I did.
And who did he apply for a loan through?
Well, we're dealing with February 2017. And
Yes.
so I object as to the relevance of that. And I think it's outside the scope of cross. I don't
Well,
know.
I'm suspecting that it's going to circle around to something you were asking about.
She asked
That's why
about,
you're bringing it up, but
she asked about default and how to cure default, and if the ranch is in her estate, he could still try to pay off the loans. I think they're saying.
okay.
Did you see that he tried to apply for a loan in February of 2017?
Yes.
And what was the amount of the loan?
I don't remember it. Could you
So
refresh my
here it is.
memory? Yes, my memory has been refreshed. There was an application for a line of credit for $350,000.
And from your review of the documents, was the $350,000 ever loaned to the defendant?
It was not.
Ms. Clark Palmer kept talking about how much equity is in the property. Does equity determine who can own it?
No, it doesn't.
And the value of the property is determined on the fair market value Do you know if that's how the tax assessors determine what the value of the property is?
No, I don't.
Sorry, repeat that question.
Can you repeat your question? The court reporter couldn't hear.
And when she keeps talking about, she was asking you about equity and value of the property. How is value determined on a piece of property?
Maybe you should ask her, given his facial reaction, if you ask the question you asked before about fair market value and tax appraisal.
Right, what is the difference between the tax appraisal value and the fair market value?
A tax appraisal value is one that's determined by the tax assessor. And the tax assessor is looking at what the tax assessor deems the property to be valued at so that they can assess property taxes. That is not always what the fair market value of the property is, even though the tax assessor may come up with a term called fair market value. The fair market value of a property is what a willing buyer and a willing seller will agree on as the purchase and sales price. And much of that is truly a matter of opinion between parties.
Okay. And Amanda Palmer kept asking you about defaulting and curing a default. On the terms of Diane McIver's loan or Clay Management's loan, did he have to be in default in order for them to foreclose?
No, he did not. They had a demand feature.
Okay, so he wouldn't have a default to cure if he was not past due or delinquent in his payments.
That is correct.
And if she asked you also about severing the joint tenants with rights to survivorship, then you said that they would own it as tenants in common.
That is correct.
What is the effect of owning the property in tenants in common? Could each person then will it to whoever they wanted to in their wills?
That is correct. When you own it as tenants in common, if you die without a will, it goes to your heirs by the laws of intestate succession. If you die with a will, it goes to the heirs that are listed in your will.
Okay. And these promissory notes that we've been talking about in these, the 2011 one that was secured by real estate and the 2014 renewal promissory note, were there security deeds attached with these notes?
Yes, there were.
And were they filed in court?
They were found in the deed records of Putnam County Courthouse.
And what is the purpose of filing your security deed at the deed records office at the courthouse?
One of the purposes is to put the world on notice that you have an existing lien on the property. Another purpose is so the county can collect its intangibles taxes that may or may not be due on the property.
Do you know when each of them were filed in this case?
Yes, I've given dates for the recording. I've given dates for the recording of those instruments.
And what was the date of recording for the 2011 promissory note?
If you give me a chance. The 2011 security deed was recorded January 24th, 2012 at Deed Book 740, page 566, Putnam County, Georgia Records.
And what about 2014?
Okay, what happened was there was a modification agreement that was done in 2014. It was a modification of the security deed that was recorded in 2012. And that modification agreement was filed February 26, 2015.
Okay. I'm sorry, what was the date on the phone?
February 2015.
February 20th.
February 26, 2015.
That's all I have.
Any questions from the jurors for Mr. Morse? Seeing none, Mr. Morse, thank you so much for your time. Appreciate it. Coming all the way from Stockbridge.
Yes, thank you very much.
Okay, you are free to go. Ladies and gentlemen, we are going to take our afternoon break. Can we, as a teaser to the jurors, tell them that the next witness isn't going to talk about joint tenancy or wills or trusts? We're getting into a different topic with the next witness.
Different topic.
Different topic. There's something to look forward to. Take yourself 10 minutes or whatever you need. I'll have Deputy Murphy check with you all in about 10 minutes. If you're ready, we'll get you back in here. We're going to talk about joint tenancy or rights of survivorship back there in the jury room. We'll see you back here shortly. Thank you.
All rise for the jurors.
Juror 5, my contact said he didn't hear from you. Are you going to reach out later? Right now. Great. Okay. Just want to make sure. Didn't want to leave anyone in.
Please be seated.
Mr. Rucker, anything from the state before we break? No. Okay. Mr. Samuel, anything from the defense? Take that as a no? As a no. Just shake of the head? Okay. Thank you. We'll be on break.
All jurors are present and accounted for, Your Honor.
Thank you, Deputy Murphy. You all can be seated. New topic. Who's the new witness?
Yeah, I'm going to say we'll call Ms. Angie Brooks.
Face me, Ms. Brooks. Raise your right hand. Do you swear and affirm that the testimony you should give the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Yes, ma'am, if you will. Please have a seat. Get as close to the mic as you can during your testimony. For the purposes of the court's record, please state and spell your name.
My name is Angelia Brooks, Angelia Brooks.
Good afternoon, Ms. Brooks. Let's begin by introducing yourself to the jury and tell them, if you would, where you are currently employed.
My name is Angelia Brooks, and I'm employed by U.S. Enterprises.
And at work at U.S. Enterprises, do you go by?
Excuse me, just 1 second. I couldn't hear over here.
Okay, if you would make sure you're speaking into the microphone, that'll project it out to folks in the further reaches of the courtroom.
Okay.
Thank you. Sorry.
No problem.
If you would, tell the jury, do you go by any other name or nickname at work?
Nickname is Angie.
Okay. And what do you do at U.S. Enterprises?
I'm the Executive Vice President.
And for your purposes, tell the jury, what does it mean to be the Executive Vice President at U.S. Enterprises or a quarry company?
With our company is a little bit of everything.
And how long have you worked for them?
36 years.
You started with U.S. Enterprises. What was your title then?
I was part-time.
Okay. And at some point, you worked your way into the executive sort of team at U.S. Enterprises?
Correct.
For you specifically, do you have a focus on an area? What do you do day to day, really?
A lot of my day-to-day is accounting.
Okay. At U.S. Enterprises, does that mean that you are sort of the internal point person on staff records as far as salary, compensation, that kind of thing?
Correct. I do handle all the HR.
And about how many employees does U.S. Enterprises have?
Right now, we have 15.
Okay.
Excuse me, the other Katie, could you put it close to the mic, please?
Do you need her to repeat? No. Okay. Tell the jury, how did you know Diane McIver?
I worked with her for 36 years.
And when did you first meet her?
After I was hired,
Do you know about what year that was?
1981.
And when you came into U.S. Enterprises, when you were first hired, what was Diane McIver's role at that time in the company?
She was president.
And did you report or work directly with?
Excuse me, she was a vice president.
Okay.
The last time I was president.
All right. When you first come into the company, are you working with Diane McIver on a regular basis directly, or is that something that happens later?
Happens later.
Okay. Tell the jury how the two of y'all's relationship kind of develops while you're employed there at U.S. Enterprises.
Well, I was hired part-time, and I had a boss who was the office manager. And when he left, she asked me to step in his role. So as the company grew and changed, we all kind of grew with it.
And a regular day at U.S. Enterprises, how often or how close would your business relationship be with Diane McIver?
A lot of the work that I did funneled to her, like P&Ls, check requests, checks issued, the ultimate approval for vacations and time off and salaries and things of this nature.
And would that mean on a regular day you would be in her office working directly with her on a pretty regular basis?
Every day we spoke or emailed or text, depending on if she was in town.
Tell the jurors, how would you describe, based on your interaction with Diane McIver, what kind of a business person she was?
She wanted everything ticked and tied.
She wanted everything what?
Ticked and tied. I mean, everything balanced to the penny.
And is that an experience, or is that a opinion that you have based on a personal experience with her?
That's just what she demanded every day. Everything balanced.
But what about outside the office? Did you have a friendship or a relationship with Diane McIver outside U.S. Enterprises?
I saw her outside.
About how often would you say?
In the year that she died in 2016, one time.
Did that, at some point from being so close with her at work, did that mean that you had, or that you at some point met the defendant, Mr. McIver?
Yes.
And when did that first happen?
Well, Tex actually worked for Fisher & Phillips, which my being in the position I was in and being a certified HR person, I interacted with Fisher & Phillips throughout the years and met Tex through going to HR conferences and things of this nature.
And you said because of the role that you were in, you worked with Fisher & Phillips on a kind of regular basis. Tell the jurors a little bit more about that.
Well, we had Fisher & Phillips on retainer for years, and when I first started, we had a lot of employees because we had service stations and convenience stores and things of this nature. So labor issues would come up or other questions about how to handle employees.
And what does it mean to have a law firm or some legal entity on retainer? What do you mean when you say that?
My understanding is that we paid a monthly amount, and then we could call and use up to X amount of time.
And how early, or how long about after you had first joined, or what year did you first join U.S. Enterprises?
1981.
Okay, and after joining in 1981, about when do you remember this sort of business relationship with Fisher & Phillips there?
I became knowledgeable about it in 1982 when I went full-time, and I took over doing the convenience store and service stations payroll.
Okay, and through the Fisher-Phillips relationship, did you get to meet and directly interact with the defendant, Mr. McIver?
I don't remember him back that early.
When is it that you first sort of remember him coming into the picture more at U.S. Enterprises?
After he and Diane started dating.
And what is your memory of about when that was?
It would have been probably early 2000s.
And in the early 2000s, when you first sort of meet the defendant, do you get to see him come into the office on a regular basis?
I don't think in the beginning it was on a regular basis. I think it kind of evolved into a more commonplace type of occurrence.
Sure. About how often towards, in the year of Diane's passing in 2016, would you say that you saw Mr. McIver actually in the office?
Several times. I'm normally busy looking down or on the computer, so I'm not paying attention to who's coming in and who's leaving.
Sure. When you say several times, describe for the jurors a little bit about what kind of occasions would bring him to the office. How is it that you cross paths with him?
He would come in on like Friday afternoons and speak.
And do you know when he came in on Fridays, who he would be meeting up with? Did you know?
He would be coming to pick Diane up.
Did you ever have an opportunity to see Diane and the defendant interact together in the office?
Yes.
Tell the jurors about that.
Well, they would interact, they would have different conversations. She would tease him or get after him a lot about, did you bring a check? Did you do this or did you do that?
Okay, let me back up a little bit so the jurors can have some sort of context. In your time working with Diane, in the role that you told us about, did you have knowledge or did you know about her making loans to people?
She did that.
And when I ask you that, tell the jurors a little bit about what kinds of things that she would make loans on.
Well, she would make loans to employees. If they needed something, like if they were buying a home or if they were doing something and needed a short-term loan. One of the last ones that I remember was there was a gentleman in our office, his daughter's Hope Scholarship had not come through, and she had given him, I think it was $1,000 so that his daughter could get enrolled in college classes.
And did your knowledge about Mrs. McIver making loans include knowledge about loans that she actually made to her husband, the defendant?
I knew about them, yes.
And did you know about sort of the main or big, the $350,000 loan?
That, yes.
Is it your understanding from your personal interaction with her and seeing her on a daily basis that these were casual loans or that she didn't intend to get her money back?
I object. Calls for speculation.
I think there's been a foundation laid about the personal relationship, but if the court would like, I can lay a little more foundation
Why
about
don't you ask at least another foundational question?
Sure.
Because you've gone from, did loans happen to, well, tell me about this one, how did you feel, how do you think she felt about it?
Sure. In addition, Ms. Brooks, to knowing that these loans existed, as part of working there with Diane McIver, did you get a chance to see her sort of manage these loans in any way?
I did. I know that one particular loan, which was several years ago, she loaned a mutual friend, Lauren Cathcart, money.
She loaned what?
Lauren Cathcart money.
And what is that?
She loaned this lady by the name of Lauren Cathcart some money.
Okay, and did you get to see her sort of manage that loan and ask for money payments and that sort of thing?
Asked for payments and get after her if she didn't pay on time.
And this was someone who was a personal friend of hers?
She was a hairdresser.
Did you know her as well?
I did.
And how is it that you came to know about her asking for money to be paid or making sure there were payments made on that loan?
Lauren asked me to help her set up a budget
Okay.
so that she could get the loan paid on time.
And the information that you know about that particular loan, is that the only loan that you've heard about Mrs. McIver making and then making sure there were payments made on?
And no, and this was just a regular occurrence. I know that she loaned Danny money from time to time. It was not unusual.
And so based on your personal experience with Mrs. McIver and being able to observe her manage some of these loans, is it your opinion that these were casual loans or that she didn't intend to get her money back?
If, in my opinion, if somebody goes to the extent of getting a note drawn up and having both parties sign it, I think that's the intent is to collect.
In your time working with Diane McIver, did you ever see her just give cash to somebody or give a loan that wasn't in a formal setup?
I've seen her give people gifts. If somebody was taking a vacation or something, and she may make a comment to me, well, I gave so-and-so $50 to help with gas.
But substantial amounts in thousands and hundreds of thousands, have you ever seen or experienced in any way her doing that in a casual manner or just giving that money?
No.
And then you told the jury that you got to see the defendant come into U.S. Enterprises from time to time. And I think you said that she would tease him about, do you have a payment? Do you have, tell the jury a little bit more about it.
And I didn't object when that came out before, but I object now to restate what Mr. McIver said.
And Your Honor, my response is that for this specific comment would be a presence and suppression. These are comments that Mrs. McIver made immediately after Mr. McIver come into the office, right when the actual event is happening, and she is able to hear the declarant give that impression.
Okay, why don't you have her maybe provide a little bit of the setting to see if it's the kind of event where a present sense impression
Sure.
exception might apply.
So just describe for me, if you can, when you said that to the jury and when you are thinking about that specific experience where that comment was made to the defendant, where that happened.
Well, in the instance that comes to mind, we had a liquor store, and a lot of wine was ordered, wine that you couldn't buy on the croak. And so there may be a case or two of wine that was purchased, and one of the things was, okay, when you buy it, you have to pay for it. So, okay, you're coming to pick up the wine, did you bring a check?
And when you say we had, you're talking about U.S. Enterprises.
U.S. Enterprises.
Give me a little bit more so that I can have an idea of who bought what and who owed who repayment for what was purchased.
Well, it was anybody that was connected with the company could buy the wine, and we would bring it up. Mr. Corey a lot of times would bring it up, and we would send the checks back down with Mr. Corey that night.
And do you know the defendant to make some of these purchases?
Yes.
And this interaction that we're talking about, is it related to the defendant making a purchase of some wine from sort of Corey's account?
Yes.
And were you able to observe Diane McIver when she made the statement that you told the jurors about?
Yes.
And what did she make the statement in response to?
Well, he would come in, and that was one of the first things that she would ask.
So it's a question?
I'm sorry.
It's a question or a statement? If it's a question, we can keep going.
It sounds like it's a question, if I understand the witness.
That's what I heard her just say,
Yes.
is that she would ask this question, not make a statement.
Yes.
Okay.
Were you close enough to the interaction to be able to hear the defendant's response to that question of, do you have a payment?
Yes.
What was his response?
His typical response, oh, darling.
Okay. When you say typical response, why do you say that?
Because most of the time, that was the response that I heard.
And what was Mrs. McIver's response to the oh, darling?
She would remind him that we would need to get the check, or
I'm sorry. Now, objection. I think we've moved on to statements and hearsay.
Agreed.
My position would be the same on the exception, but my questions are limited to that. So
Okay,
I'll move on.
let's move on. I'm going to sustain the objection as to what was said after your immediate reaction.
In your time working with Diane McIver, are you close enough to her, either being in her office or being around the office, to be able to observe her on the phone?
if we had meetings in her office, yes.
And from being actually physically in her office, have you ever observed her on the phone with the defendant?
Yes.
While you observed her on the phone with the defendant, did you ever observe any frustration on the part of Diane McIver as a result of that conversation?
Yes.
And when you say that, tell me what you mean.
Just objection to this extent the question calls for hearsay about what Ms. McIver said.
Sure, so let's make sure that whatever answer is given, you didn't ask for it, let's make sure it's not included in the answer.
Right. And just tell me what you were able to observe personally. Not what anyone said necessarily, but what made you be able to say that yes, she was in fact frustrated.
Facial expressions and putting down the phone very hard.
And how is it that you know she was on the phone with the defendant?
From the conversation.
When was the last time that you saw Diane McIver before she passed?
Friday before.
And you were working at Corey that day?
Yes.
And tell the jury about what time you saw her, if you remember.
On and off throughout the day.
Do you remember the last time that you saw her that day?
The last time would have been when she was walking out.
Did you see who she was walking out with?
There was several people there that was walking out. I remember Danny was one of them.
Okay. Do you remember about what time that was that they left that day?
It was before I left, so it would have been before 6.
Okay. And you know you left at 6?
Yes.
Okay. Did you know that they were going to the ranch that weekend?
I did not know for sure, but that's typically where they were going.
Do you say typically because it was a Friday and there was a weekend, or because some person was there that made you think they're going to the ranch?
Usually when they were going to the ranch, they would be at the office.
Okay. And did that mean that Mrs. McIver's car was usually at the office as well? Did she would leave it over the weekend, or did she usually drive, in your experience with them, leave it and go into the ranch?
Sometimes she would leave it at the office because we have a garage and it can be locked up and secure.
What is the car that she typically drove to work?
A Jaguar.
I'm sorry.
A Jaguar.
That weekend, did you have any communication with Diane McIver?
No.
And when is it that you first learned that she was actually killed?
When I walked into the office on Monday.
And don't tell me what they said, but how did you learn that she was killed?
Several people were talking about it and just the general conversation between several different people.
And in that general conversation, at some point, did you sort of get an announcement, or did you all announce with Mr. Corey and Mr. Grover what had happened?
That was later when after Corey got there.
When you first came in that morning, did you know any details or how Diane had been killed?
When I first got there and started overhearing the conversation, I started thinking, oh, it was a car accident.
Fair to say there weren't too many details floating around when you first got into work that morning.
No.
After you came in that morning, about how long is it until this Mr. Grover and Mr. Corey announcement? You come in and you first learn it, when does that happen?
Well, everything was kind of in like a twilight zone, but it was a couple hours.
Did you ever talk to the defendant directly after Diane's passing?
Only time was in passing at the memorial service
And when you say the memorial service, where was that?
at our office,
Do you remember about when that was?
late October.
When you talked to the defendant in passing, at that time at the memorial, did he give you any details about the circumstances around her death?
No.
During those first few days, that Monday and sort of the first week that followed, do you remember being around for any speakerphone conversations with Mr. Grover and Mr. Corey?
Yes.
Do you remember the defendant being on speakerphone during any of those conversations?
Yes.
During those conversations, did you hear the defendant provide any details about the circumstances of the shooting?
There was a few, not in minute details.
What did he say that you heard?
He was trying, or he was explaining what happened,
And what did he say happened?
that the gun went off.
Did you or anyone else in sort of the speakerphone group ask any questions?
Not that I remember.
Do you remember what day that would have been in that first week?
No.
Okay. Okay. As part of your sort of the many responsibilities you have at U.S. Enterprises, one of them being responsible for benefits and payroll at the office.
Correct.
And early in that first week or week and a half, did you reach out to the benefits, sort of the third party that goes in between your benefits there at U.S. Enterprises?
I think it was around the 1st of October.
Okay. And why did you do that?
Well, we have...
I'm sorry. Your Honor, can we approach just briefly?
Well, we have life insurance through our health insurance package, and then we have the 401k plan. It's company sponsored. So we wanted to make sure that when the time came, that we knew exactly how to handle it.
And once you learned about, did you, as a result of reaching out learn about who the beneficiary of Diane McIver's policy or 401k in the office would be.
Yes, since we didn't have a form on file that said who her beneficiary was, I contacted Guardian and I contacted our third-party administrator and said, okay, this is the circumstances. I'm married with no children. Who would be the beneficiary? Who should we start that process with? And so they responded.
And sometime, when you say guardian, just so the jury understands, what is guardian?
Guardian is the person that holds our 401k money and invests.
Okay.
I'm sorry, that holds.
Our 401k money and invests funds.
After this initial reach out and learning that information, do you at some point get contacted by the defendant and or Ken Rickard?
From my remembering, the defendant contacted Mr. Rickard. Ken referred him to me since I'm the plan administrator, and I forwarded the forms and documentation along with the email saying that you need to fill these out and get them back to me because I have to sign them and submit them.
Was that the end of the correspondence?
For a while.
When you say for a while, why do you say that?
Well, that went out in the 1st of November, and I didn't hear anything. I didn't get any forms back. And then I started getting other emails that, that they couldn't find them. They probably mislaid them or something, and so they were resubmitted to them.
Okay. And when you say other emails, who did you understand them to be from?
They were from Tex to Ken, and they were in with other items.
Okay. When you say forms, what forms are you talking about?
It's the 401k death benefits withdrawal.
I'm going to show you what's been marked as State's Exhibit 453. You recognize that?
Yes.
And when you flip through the whole packet for me, do you recognize all those pages?
I do.
And does it appear to be a true and accurate copy of the forms and then the final correspondence where you got the completed forms, this paperwork from Guardian that we've been talking about?
This is the paperwork submitted by Tammy to us to start the 401k withdrawal.
And who is Tammy?
Tammy was a person working with the estate in the beginning.
From your initial reach out that we talked about there in the first week of October, and from your work in the capacity that you're in at Corey, does this policy get paid out to the defendant as an individual or to the estate?
My understanding from the information I got, that it was paid out to the individual.
Okay. Have you since been in a position where you are able to see the balance of, since this date and the date of the paperwork you have there in front of you, have you been able to see the balance of that account, Diane McIver?
The last statement that they sent me, it's zero.
What is the amount of the approximate amount of the 401k policy that U.S. Enterprises had in relation to Ms. McIver?
It's probably around a little less than 400,000.
Ms. Brooks, after Ms. McIver's passing, are you familiar with the time frame where individuals would have come into the office to get into the lock safe in her bathroom?
I know that there was a locksmith called. I was not involved in that.
Okay. And when I say lock safe, I mean the lock file cabinets, and I'm going to show you what's been already admitted in State's Exhibit 139. Do you recognize this picture?
Yes.
And where is this within U.S. Enterprises?
That is in her personal bathroom.
Okay. And you were actually not physically present when they came in to get whatever they got out of the locked cabinets there?
When they unlocked the cabinets, no.
And in your time working with Diane, did you know these cabinets that we see in 139 to be a location where she kept important documents?
She kept important documents. She kept company documents. She had a variety of things in there.
And had you ever actually personally been in those file cabinets?
No,
Did you ever know them to be unlocked or left open?
no.
In your conversations with Diane, had you ever talked to her about her will?
We did.
I'm going to show you what has been already admitted as State's Exhibit 441. I'm going to direct you to the back 2 pages here and have you take a look at that for me. And let me know on those back 2 pages if you see your name anywhere.
I do.
Put it up so the jury can see it as well. State's Exhibit 441, back 2 pages. Can you describe for the jury what generally this is, what we're looking at?
It's ruby and diamond pieces of jewelry.
Okay, do you see other names besides yours on there?
Yes.
Tell the jury if you know from your friendship and your professional relationship with Diane McIver, did she have a good amount of nice jewelry?
She did.
And had you ever actually talked to her about specific pieces that she owned?
I did. She had a brooch that was...
I'm sorry. I'm just going to object to the content of the conversations with Ms. McIver as hearsay.
Okay, I mean, I don't think she was getting into what Ms. McIver said yet, so you can, the way you were answering was okay for now.
There's a piece in particular that you had a conversation about. What was that piece of jewelry?
So still, I'm sorry, stand objection. The content of the conversation is about this piece of jewelry. Hearsay.
Okay, noted, you can keep going.
She had a very good size brooch. She wore it on a necklace, and it had a ruby and diamonds around it, and she's had the piece for quite a while. And since both of our birthdays were in July, rubies were significant to both of us, and we would have a conversation about that.
Okay. Tell the jurors, what items do you see on this list with your name next to it?
Ruby and diamond ring, ruby and diamond bracelet, ruby and diamond earrings.
And what is the title of this document, Exhibit number 41?
Last will and testament of Diane S. McIver.
Can you read the date there on the very bottom?
February 1st, 2006.
All right, I'm going to show you a couple pages of what's been admitted as 401. I'm going to have you take a look at both of those yellow tab pages for me. And the third one as well, actually. I'm going to start with the last tab you looked at. This is going to be page 300 of State's Exhibit 401. Can you tell the jury, do you recognize what's depicted there on that page?
Yes.
And is that the brooch that we just talked about?
Yes.
And what you see on page 192, page 51, consistent with the items that we just saw next to your name on the back 2 pages of that will.
Yes.
And can you tell how much each of those items was listed for? I'll go back and show you. But starting first with this bracelet.
$3,000 to $5,000.
And the earrings.
$1,800 to $2,400.
The brooch.
$6,000 to $8,000.
So that says tourmaline, I have no idea what that is. Is that red? Because you've been talking rubies, and I don't see ruby there. I'm not
It's
quibbling
there.
gems with you.
It's there. If you look at it, it says ruby light tourmaline.
Okay, so tourmaline is it's red.
Red.
Great. Thanks for me.
And as you sit there today, have you received any of those items?
No.
Just one moment, Mayor. Ms. Brooks, you told us about a speakerphone conversation in the first few days after Diane McIver's passing. During that conversation, as a result of what you heard, did you actually print an article?
There's been various articles that's come out in the paper that we printed, especially for Mr. Corey, who doesn't like to use a computer.
Understandable. And during this specific conversation, is there a statement that the defendant made about the case that caused you to print a certain article?
So there's been multiple articles that I have printed for him, but early on there was different statements that were made that caught our attention.
And when you say different statements that were made, were these statements of the defendant?
Statements of the defendant, statements of I think the gentleman's name is Bill Crane.
Okay. And were any of those statements, if you can remember, statements that the defendant made while you were all in speakerphone right there in the office in the first few days after the murder?
I don't remember specifically.
Okay. Are you still working for U.S. Enterprises?
I am?
And what is your current role there? The same as you just told the jury?
Yes.
And does that still include a responsibility to the HR and sort of the internal workings of exec there at U.S. Enterprises?
Correct.
I don't have any other questions, Your Honor. Let me redirect.
Good afternoon, Ms. Brooks. My name is Amanda Clark Palmer. Thank you. And I just have a few questions for you. Did I hear you say that part of your function at U.S. Enterprises included payroll?
It does.
All right. Did that include Ms. McIver's salary and payroll?
It did.
What was her salary at U.S. Enterprises in 2016?
She had different components of her salary. She maxed out for Social Security through the payroll, but she took other compensation through rents.
So when you say she had different components of her salary, what are you talking about? What are the different components?
Well, like I just said, she would take a salary to max out on her Social Security, and then she would rent back to U.S. Enterprises various items or pieces of property.
Is it just those two things that you're talking about, the way that she would get some kind of money or compensation from U.S. Enterprises?
That's all I remember at this time.
What was her salary?
Are you talking about total?
In 2016, yeah. When you say she maxed out her Social Security, what was her salary?
If I remember correctly, it'd be about $120,000.
Okay. And the other compensation from the rents that she got, do you remember what that number is?
Not altogether, no.
Okay. Can you give us an idea? Are we talking about like $10,000, $50,000, $100,000?
It was probably well over 200.
Okay. And you told us about the 401k, and I want to make sure I understand the timeline correctly. In early October, you reached out to Guardian, the plan administrator, and said, who is the beneficiary for this 401k?
I reached out because we didn't have a form on file.
Okay.
And to find out, did they keep anything from the original sign-up, or did they know what the procedure would be?
And that was an action that you took on your own?
We took that in conjunction with the life insurance, with the health, and the 401k.
Okay. At that point in time, you took that, you did that action not because Mr. McIver had called up and said, hey, do you have the document that says who the beneficiary is, correct?
Yeah, we've not had that many people to pass away, so we wasn't sure exactly what's the procedures.
Right. It was later on in November that there was some communication with Mr. McIver about needing to get the forms.
Early November.
Early November about needing to get the forms filled out so that he could get access to the 401k account, correct?
Correct.
Okay. And then the form, the completed form, gets signed by Mr. McIver in December 2017, correct?
That was the date that was on the form.
Right. Okay. And you said that you think the value of the 401k was approximately $400,000?
Possibly the last number that I can remember was around there.
And that's just going off the best of your recollection today.
Yes.
If we wanted to get the number, we ought to look at a document, a bank document or a document from Guardian itself, correct?
Guardian issues plan statements.
Okay. Is it possible that the value of the 401k was more like $280,000?
I couldn't tell you 100%.
Just need to find a better person to ask, correct? Somebody who's looked at the document and knows what it says.
Well, other than myself and Richard Harrell at that time was a trustee, there was not a lot of people looking at it.
Because there's some document out there from Guardian or something that
Yes.
says what the value is.
Yes.
Okay. And that's where we ought to look if we want to know, hey, what was the exact value of the 401k?
But 401ks go up and down with the stock market.
The value at the time it was paid out, right?
Correct.
Okay. All right. Thank you, Ms. Grace.
Any redraft?
Mayor.
Any questions from the jurors? Deputy Burke, if you wouldn't mind getting those, please. Proceeds of Ms. McIver's 401k were paid.
According to the form, the documents, it was paid to an account under Claude McIver.
Okay. There was a handwritten list that you looked at, that was shown to you, that listed some jewelry with your name next to it. What was that form attached to? What was the document that was attached to?
It was attached to her last will and testament.
Did you ever borrow jewelry from Ms. McIver for events or special occasions?
No.
You mentioned when discussing the ways in which Ms. McIver was compensated that there was rent income. Would that have been on a W-2, or what kind of form would rent income be reported?
1099.
Do you know if anyone who had the code to get through the front door at U.S. Enterprises could come in the middle of the night? Or was there instead an alarm set, so you need to know an additional code so that things didn't get messy?
Well, there's a code on the gate, there's a code on the front door, there's a lock on the front door, and there's an alarm.
Okay. So if it's the middle of the day and I have the code for, I guess, everything on the outside, gate and front door, I can get in the building.
Correct.
If it's midnight and all I have are those two codes, can I get in the building?
No.
All right. Any follow-up, Ms. Conver?
Mayor.
Ms. Clark-Paul? Not even on that small Post-it? Okay. Thank you for your time. Next witness.
Stay with Mr. Andrew Wilcox.
Raise your right hand. Do you swear and affirm that the testimony you should give the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Yes, sir. If you will, have a seat. During your testimony, get as close as the mic as you can. For the purposes of the court's record, please state and spell your name.
Andrew James Wilcox, A-N-D-R-E-W, James, J-A-M-E-S, Wilcox, W-I-L-C-O-X.
Good afternoon, Mr. Wilcox.
Good afternoon.
Could you introduce yourself to the jury and tell them what you do for a living?
Yes, my name is Andrew Wilcox. I live in Tallahassee. I'm the owner of Wilcox & Hackett, which is a legal recruiting and consulting company.
And how long you said Wilcox and Hackett. Are you an owner of, or part owner of that business?
Yes, sir.
And how long have you owned and been a part of that business?
Since 2003.
And you said that you did legal recruiting, or that business did legal recruiting. Could you explain to the jury what that is?
Yes. So I work with attorneys in terms of trying to learn their goals, their career goals, and then ultimately trying to place them in a different law firm, whether it's primarily I work with partners in groups trying to get them to move from one firm to another that may be a better fit for their career.
And you said you partners in groups. Are you typically working with I guess experienced attorneys or attorneys who have been in the industry for some time, or brand new lawyers?
Primarily partners which are, they've been in the industry for a while.
Now, did you have an opportunity to, I guess, meet Mr. Claude McIver, the defendant?
Yes, sir.
Okay. And do you remember what year or how many years ago that was?
It was around 2010, 2009, 2010.
And what were the circumstances or the reason for your meeting?
Primarily trying to learn about his practice a little bit more and trying to figure out if he would be a good candidate, potentially him or a group from his firm, to be able to either start up an office for another firm or to be able to merge his practice with a firm in Atlanta.
Okay. And was that the last time you spoke to him, or did you stay in touch with him throughout the years?
I have. I've stayed in touch with him throughout the years.
Okay. And can you tell the jury, I guess, the reason and how you remained in contact with the defendant?
Primarily, I just stayed in random contact whenever there was an opportunity that came up, whether it was a firm that was looking to open up an office in Atlanta, or if it was a firm that was looking for a labor and employment partner or a small group in Atlanta. Just kind of maintaining a relationship. I had met with them, with Fisher and Phillips, to actually have dinner and discuss client development training briefly at their office as well. But that's a few years ago as well. But primarily just to kind of stay in touch if there was an opportunity that arose.
Okay. And when you stayed in touch, was it typically through, I guess, phone conversations or emails, or did you have, I guess, face-to-face conversations each year?
No, we just had that one face-to-face when I met, and then I ultimately met with the folks at the firm over at Fisher and Phillips. But for the most part, it was the phone. I'd sent emails, but then emails started getting blocked. Firms don't like it when people try to take their attorneys. So my emails started getting blocked, and ultimately I ended up just calling him. I had his number, so I just reached out to him.
Okay. And after, I guess, Fisher and Phillips blocked your contacts with Mr. McIver, the defendant, or any other attorneys at Fisher and Phillips, how did you communicate through email with the defendant?
I called him on the phone, and I just said I had emailed him, and the email had bounced back, and he said to send the email to his wife's email account, which happens from time to time. Not necessarily just that, but just I try to maintain a confidentiality with attorneys, and sometimes that's a Yahoo address, or sometimes that's their kid's email address, just other ways to correspond with them.
And his wife, did you ever have an opportunity to speak to or meet Ms. Diane McIver?
No.
Now, in the middle of September of 2016, did you have an opportunity to speak with the defendant?
I did.
Okay. And tell the jury what that conversation or the reason for the communication was for.
Okay. I had a firm that was out of Texas that was looking to expand into Atlanta, and I had known Tex. I know as far as trying to open up an office, they were looking for a group to be able to do that with. And so I contacted him and I said, I've got this opportunity. Would he have an interest in it? And he indicated that he may. And we just stayed in correspondence with each other. And he had a conference, I believe he was going to in Texas. And the managing partner from the firm was in Dallas. He was going to be in Dallas. So I said, well, if you're going to be in Dallas, why don't we try to line up an initial meeting with you all out there? It's very preliminary, but it was while he was going to be out in Texas to be able to set that up.
And do you remember the name of the firm?
It's Wilson Elser.
Okay. And I guess throughout that conversation, did compensation or salary come up?
It did, just somewhat vaguely in terms of what requirements would be. Again, it was a very preliminary discussion, but just vaguely just how much it would take for him to be able to make a move.
Okay. And do you remember how much Mr. McIver told you that would be necessary to require him to make a move?
He just indicated it was going to have to take a lot of zeros with a 1 in front of it. So I took that as being somewhere over $1 million.
And I guess throughout that conversation and throughout the years, for that matter, did Mr. McIver ever indicate to you that his partnership status at his firm had changed?
No.
Did he ever indicate through your conversation, whether it be in that September of 2016 or throughout the years, that his income had been decreased each year?
No.
Okay. Did he ever mention to you during that conversation in September that he was considering or planning on retiring?
No.
Through your conversations with Mr. McIver, did you, or did he express to you that he wanted to continue working?
That was my indication because he was looking to potentially explore an opportunity with Wilson Elser to go over and open up an office with them with a group. So.
Now, you said with a group. Did he give you, I guess, the number of people he would be able to bring to a firm that was expanding here in Atlanta? To Atlanta.
He just indicated a group here. There had been a group, I think, in some other cities, some attorneys in some other cities that he felt like he'd be able to potentially bring on. But it was very preliminary in terms of what the what that size of group would be, and even kind of the revenues and some of the other things that we would go deeper into.
And I guess during that conversation, did he ever talk about his book of business?
No.
Okay. I guess through the years, did he ever tell you how large his book of business was?
No, but I just in taking some context in terms of how long he'd been with his firm, the partnership level he'd been with his firm, the meeting that when I did meet with him, I knew that he had experience with the firm. Being able to bring a group with him, that was my indication that there was a level in doing what I've done for as long as I've done. You kind of start picking up on folks who have a strong practice and folks who are more service partners, I guess you could say.
Okay.
So.
And after that conversation, did you set up a meeting or attempt to set up a meeting with the firm in Texas?
I did.
Okay. And did you communicate the date at which that meeting would take place?
I did.
And I'm going to show you what's been marked as States Exhibit 219. And if you will just take a look at it and let me know if you recognize it.
I do.
Okay. And how do you recognize it?
That's my email address. That is to him. That's my email signature, and then the dates and the date and the time and the gentleman that he would have been meeting with in Texas.
Okay. And is State Exhibit 219 a fair and accurate copy of the email that you sent to Mr. McIver about the meeting?
It is.
This time around, the state would tender what's been marked as State's Exhibit 219 as evidence.
No objection.
Submitted.
Yes, Judge. And Mr. Wilcox, can you tell the jury when, on what date, let me zoom out for you, Mr. McIver was to meet with the law firm out in Texas?
October 14th.
Okay. Now, did that meeting happen?
No.
And after this conversation, did Mr. McIver contact you about his wife?
He did. In fact, to cancel the meeting, saying that he wouldn't be able to make the meeting.
Okay. And during that conversation, did he tell you what happened to his wife?
He said that she died tragically, accidentally, and unexpectedly.
Did he give you any other information or details about his wife being killed?
No.
Okay. Do you remember how long that conversation lasted? Was it a long conversation? Was it short?
It was somewhat short. I assumed that it was, that she passed away with a heart attack or car accident, and I just didn't want to, get too much into it with him. I just said, my thoughts with him, and just kind of closed the conversation there.
Do you remember during that conversation if he told you, I guess, how long his wife had been gone, or how long she had passed? The day.
I don't remember exactly how many days it was. It was within, I'm going to say, a couple of days. So.
And I guess during the conversation with you, was he crying uncontrollably?
No.
Okay. Do you remember him crying at all?
No.
Okay. And after that conversation, did you have the opportunity, or did Mr. McIver contact you again?
It was a couple weeks later.
Okay. And so that would that be in October?
Yes.
Okay. And what was the purpose or the reason that Mr. McIver was contacting you then?
Potentially to reset the meeting. He indicated that he had spoken with his psychologist. The psychologist had indicated that he needed to get, and I'm not quoting this, but to start getting back into the swing of things. And we were going to try to reset that meeting. The reason why we were trying to have that meeting in Dallas, though, was because the managing partner lives in Dallas, and it was just an opportunity, since Tex was going to be in Dallas, to have that meeting.
Okay. And were you able to set up another meeting with the defendant and the firm in Dallas?
No.
Okay. And after, I guess, well, during that conversation, did Mr. McIver tell you anything about, or anything additional about how his wife was killed?
No.
Did you speak to him again?
No.
Okay. And after your last conversation, did you find out or learn how Mrs. McIver was killed?
I did.
Okay. And without telling me what you learned, how did you learn, or where did you get the information from?
It was from the AM Journal, which is a journal for attorneys, or just kind of a periodical that comes out. I get an email like once a day on stories and things that are happening in the legal field.
And is what you read what Mr. McIver told you on, I guess, after his wife died, what happened?
I would object, Your Honor, to comparing what you read with what Mr. McIver told him. It's really based on hearsay, and I don't think it's relevant.
I don't know about the hearsay part so much, but the relevance part. So we got apples and oranges here. We don't know what went into. Great.
And had you had any further contact with the defendant since your last conversation?
No.
A couple other questions. Would you have considered Mr. McIver for, I guess, the job placement or the firm placement in Texas if you had known that his salary had been decreasing over the years?
I would have questioned it, simply being that if his salary had been decreased, I would have wanted to know if it had been tied to his book of business, the level of business that he was able to bring with him. If that had decreased quite a bit, then candidly, his candidacy probably wouldn't have been as good, other than the fact that he had been in the market for a while here. The legal market, and to open up an office with somebody that had been in the legal market may have still had value, but candidly, if you hadn't had that level of book of business, it would have made it much more of a tricky placement, I guess you could say.
Now, and based on, I guess, your experience, the number of years that you've been in this business, was the request of $1 million or over $1 million reasonable, in your opinion, that Mr. McIver was making?
Objection to relevance, objection to his opinion.
Great. I think the opinion, based on who you're asking the question of, is okay. What's the relevance as to whether this witness thought that was just right, a little rich, or gosh, we should go higher? You should ask the guy who's making you ask that.
I have heard that the relevance is based on
Objection to hearsay.
the state's response would be that based on the testimony that's come out from previous witnesses and throughout the day about the $350,000 and being able to satisfy the $350,000 debt to Mrs. McIver, the $1 million request will be relevant due to that.
May I add to my objection?
Sure, you got a third?
We're going to be getting into bank statements, financial information that seems like the better source to look to for what the ability was vis-a-vis this loan, somebody's initial hopeful offer of what salary they may aspirationally like to get doesn't seem particularly relevant to whether or not they have the ability to pay something off.
And my response would be, the fact that we are getting into bank accounts and bank statements is the reason why it makes the request highly relevant.
So I'm going to ask the witness a question. Did you, sir, ever share with the defendant your sense of how realistic or not one followed by a bunch of zeros was as a salary that Mr. McIver might be able to command?
I just indicated that if he was able to bring a group and he was a catalyst for growth for a firm that wanted to come into the Atlanta market, that it wasn't unreasonable, depending on the level of book of business he may have had, but also on, like as I said, if he were to bring a group with him and he was somewhat of a rainmaking partner that brought other attorneys with him, that would be a reasonable investment if all things considered. I'm just thinking of it in the abstract. That wouldn't be an unreasonable request, especially in a market like Atlanta.
Okay. Clerk Palmer.
Thank you.
Bearing the burden today.
Yeah. Good afternoon, Mr. Wilcox.
Good afternoon.
I'm Amanda Clark Palmer. We've talked on the phone before, but it's nice to meet you.
Nice to meet you.
I missed when you told us that you kind of first thought you met Mr. McIver. When was that? Just like kind of year?
I want to say it was 2009, 2010.
Okay. And you met him because you came to his firm and did you come to his firm and do a presentation or something like that?
I met him initially through a phone call or email, and then we had spoken about client development training, which is one of the things that I do as part of my company. He indicated that that's something that his firm may have an interest in, and asked me to come up and to be able to speak to the firm and present just kind of a breakfast type meeting with other partners, I guess you could say, at the firm. I came up the night before. We had dinner with himself and another partner, and we went over how the next morning was going to go, and then I came in, presented, and left that morning. So,
when was that presentation? Was that also in 2009 or afterwards?
I don't remember, candidly. I want to say it was after, but I believe so. I think it was around that time frame. So,
around the 2009 time frame?
I believe so. Yeah, it's going back a few years.
And then you kept in touch with Mr. McIver over phone and email?
Yes.
And about how many times do you think you would have some kind of contact with him? Like once a year, once a month, once a week?
Probably a few times a year, maybe. Just, it depends. I mean, usually in what I do, my busy time of year, I guess you could say, is when attorneys get their bonuses and they're looking to explore their options, which is sometime usually between Labor Day and Valentine's Day, as a kind of my rule of thumb, I guess you could say. But that's, otherwise, I'd probably be in contact with him a couple of times a year.
Is it fair to say that you all had a business relationship? As opposed to a friendship?
Acquaintance, I would say, yeah. A bit more business, but yeah, when we talked politics and, just kind of caught up in, kind of the world as we see it, so yeah.
Had you ever been to his house?
No.
Do you know where he lives?
Just off of what I've read, I don't know an address, but yeah.
Yeah. Setting aside maybe something that you read, do you know where he lives because he's told you, come over to my house or invited you over or something like that?
I've never been over. I thought he said something about living in Buckhead, but I don't know if that's the case or not.
Okay. And has he ever been to your house?
No.
And have you ever gone or attended any purely social functions with Mr. McIver?
Other than the dinner that evening, no.
Okay. But the dinner that evening sort of had a business aspect to it?
Correct.
All right. And did you ever meet Diane McIver?
No.
All right. Knew her name because you used her email address to communicate with Mr. McIver.
Correct.
Yeah, bless you. You had some idea of how long Mr. McIver had been a practicing lawyer, right?
I did.
And you had some idea of his age, right? I'm sorry, you have to say yes or no. For
Yes, I'm sorry. I'm sorry,
Okay.
yes.
All right, so it's not as if you thought that he was in the beginning of his career, correct?
Correct.
All right, you knew he had been practicing for quite some time, right?
Correct, yes.
And you have dealt with before lawyers who are aging and maybe even though they're aging, still looking to leave their firm and go somewhere else, correct?
Yes.
Sometimes firms have like a mandatory retirement age where they tell partners you have to stop working, right?
Yes.
And those people may come to you looking for further employment.
Yes.
And so the fact that you were asked on direct exam, with the fact that his partnership status changed at the firm, from equity partner to income partner, or the fact that his salary was going down, would that kind of affect how you, I guess, sort of, viewed maybe his marketability? And you said you would need to know a little more information, right?
Yes, if he had been de-equitized as kind of a term that firms use, mandatory de-equitizing at a certain age or something like that, that's one of the things that firms do, some firms do. That wouldn't have given me pause as much as knowing that salary had been reduced and some of those other things. Sometimes firms make attorneys of counsel or non-equity partners or something like that. But had his salary been reduced, those would have been questions that have come up. And frankly, they would have come up in a lateral questionnaire had the process gone further, because he would have had to indicate clients and some of those type of things that firms do in due diligence.
Right, there you would want some more information, like, okay, well, do you have clients who are loyal to you that you think you can bring with you? How much are their billings? How much work are those clients going to potentially be for a new firm if you go there, right?
Yes.
Okay. And you told us about that he made this comment about, the number for him to make a move would have to have a lot of zeros with a one in front of it, and you told us that that was just sort of a vague kind of preliminary conversation you all were having.
Right, yes.
All right. And the email that we looked at in states, thank you, 219. Both of these emails in 219 are from you to Mr. McIver, right?
Yes.
The first one's in March 3rd, 2016, correct?
Yes.
And then there's it just appears from this document that maybe you replied to that email or forwarded it or something on September 30th, 2016, correct?
Yes.
Okay. And you had a later conversation with Mr. McIver later in October of 2016 where he reached out to you, right?
Yes.
Okay. And it was an email, to the best of your memory, right?
And in October, it probably would have been a phone call because that would have been after this.
Okay. But he reached out to you and he told you that his psychiatrist or psychologist had recommended to him that he ought to kind of get back in the swing of things and go back to work.
Yes.
And so he was reaching out to you to say, hey, is this, still a possibility, or can the meeting go forward, or whatever?
Yes.
All right. And when he told you that his wife died accidentally, tragically, and unexpectedly, you didn't press him for details.
No.
You didn't feel that that was appropriate for you to do at that time.
Correct.
And given that you've described your relationship with him as sort of business acquaintances, it just didn't seem appropriate for your relationship to start asking him questions about, well, what do you mean by tragic? What do you mean by accidentally, correct?
Yes. I just didn't feel like it was my place.
Right. All right, thank you. Have a safe trip back home.
Oh, thank you.
Not quite yet.
Oh, sorry.
That's the last time I get to say
I'm sorry.
Yeah.
You think I know these things, working with attorneys.
The conversations where Mr. McIver was contacting you, what were the last 4 digits of the phone number?
8685.
That's it. Thank you.
Still not quite yet. Any questions from the jurors? Here comes one. Next witness.
The state calls Nicole Carroll.
However, I did hit the jurors wanting to go to 6 unless we had a good breaking point for an early exit. With the court being inclined to inquire if the jurors would like to perhaps break and pick back up tomorrow morning.
Not yet.
Not yet. Okay. Okay. We've got a short one.
Great.
Raise your right hand for me, ma'am. Do you solemnly swear or affirm that the testimony you should give the court is the truth, the whole truth, and nothing but the truth, self you God?
Yes.
You may be seated. State your name for the court, please.
Nicole Carroll,
Spell it for the record.
Nicolecarroll.
Good afternoon, Ms. Carroll.
Good afternoon.
Please introduce yourself to the jurors. Tell them your name again and where you currently work.
I am Nicole Carroll, and I am employed with the Georgia Bureau of Investigation, Division of Forensic Science, also known as the State Crime Lab.
And what do you do for the GBI?
I'm a forensic DNA analyst.
And tell the jurors, what does it mean to be a forensic DNA analyst?
I receive evidence from state and local agencies and perform DNA analysis on the evidence.
And do you have a background and a training that allows you to do the job that you just told the jurors about?
Yes, I do.
Tell them.
I have a Bachelor's of Science in Cellular and Molecular Biology from Auburn University that I obtained in 2012. I went on to obtain a Master's of Science degree in Forensic Genetics from the University of North Texas Health Science Center in 2015. After being hired on by the GBI, I underwent a year-long training process in which I learned the policies and procedures of the lab. I handled mock evidence, and I took written, practical, and oral exams.
And as part of your employment with GBI, do you continue to get trainings and updates on a regular basis?
Yes, we do.
And as part of your employment there with the GBI, do you have an opportunity now to look at and examine cases and evidence related to current active cases?
Yes.
As part of your work there, have you testified in court before?
Yes, I have.
And have you been tendered as an expert before in the state of Georgia?
Yes, I have.
Your Honor, at this time, the state would tender Ms. Carroll as an expert in the field of forensic biology.
Jarvis?
No objection.
No objection. This is why we stayed a little bit later. So Ms. Carroll, you are qualified for the purposes of this trial as an expert in the field of forensic biology.
And Ms. Carroll, in this instance, did you have the opportunity to review the report and work of another scientist in your office?
Yes, I did.
Tell the jurors a little bit about how that came to be.
So we have a process called peer review at the lab. And what that means is after a scientist has finished their testing and written their report, a second scientist then reviews their entire case file and makes sure that policies and procedures were followed appropriately and that we agree with the findings. And after that, then the case is released. So in this particular case, I am the peer reviewer, so I reviewed the work of the initial scientist, make sure all the policies and procedures have been followed, and then I agreed with the findings.
And the scientists for this particular case, for this section or this report, are they still employed by the Georgia Bureau of Investigation?
No, they are not.
Okay. Any issue or any reason related to their unemployment that would affect their conclusions of the report or anything you reviewed?
No.
When you say you review their entire case file in the peer review process, what does that include?
I review their extraction sheets, I review every step of the process, I review the data, so with the DNA profiles that they obtain from the evidence, and I check any controls in the case file, and then I read the report and make sure that it is accurate.
The conclusions in the report that were generated in this case, did you review specifically as part of the peer review process?
Yes.
All right. I'm going to show you what's been marked and shown to Defense Counsel as State's Exhibit 309. Take a look at that for me. You recognize it?
Yes.
And how do you recognize 309?
It has the unique GBI case number on it. It has the items of evidence that were tested in this case, and I recognize the scientist signature at the end of the report.
Okay, and does 309 appear to be a true and correct copy of the report that we've been talking about and that you personally reviewed as part of this peer review process?
Yes, it is.
And attended 309 as evidence?
Is there evidence? The
Yes.
report?
So, into the record, it sounds like they want it to be made part of the record, whether it ever sees an overhead projector or jurors' eyes will be a discussion at a later time.
Okay, for record purposes only, thank you.
I'm admitting it for record purposes only. At this point, we need to have another discussion if we're moving beyond that. And I assume we're going to hear that again, if not from you, from your colleagues, if we happen to hear from other witnesses from the GBI.
Yes,
And
of
so,
course, all the scientists will be testifying about their conclusions in the report, but we understand they would not go back with the jurors.
so any other reports from other GBI witnesses, should there be any, would be for record purposes only?
Yes,
Okay.
subject to any caveat of my colleagues, but yes, that's my understanding.
And it's a safe representation.
Okay. State's Exhibit 309, you mentioned a unique GBI case number. Tell the jurors what you mean by unique GBI case number. How does that come to be assigned?
When evidence is received by the lab, we have evidence receiving personnel that receive the evidence, make sure that it was properly packaged, sealed, make sure that we have a submission form that indicates what is being submitted for the case. They then create a case in our system, and that's how you get the unique individual case number.
And if there are different services or different GBI scientists working on multiple pieces of evidence for one case, will they all track that same GBI case number?
Yes.
And what is the unique GBI case number for this particular case?
It is 2016-1028-446.
And for the evidence you received in relation to the testing you reviewed, what agency submitted that, or who sent you the evidence?
The initial item was submitted by the Atlanta Police Department.
And in this case, for what you reviewed, what did you receive from the Atlanta Police Department?
Seems like we received a sealed package containing evidence, forensic biology, firearm analysis, and that happens to be a Smith & Wesson .38 special revolver, according to the description.
And did you receive anything else from the Atlanta Police Department related to the testing that you did?
No.
I'm going to show you what has been marked as State's Exhibit 459. I want you to take a look at that. And then after, I'm going to ask you a question about the front, and then I'm going to ask you to open it. State's Exhibit 459, do you recognize the unique GBI case number that you just read off to the jurors on the front there?
Yes.
And inside State's Exhibit 459, what's contained inside?
Two envelopes.
And the envelopes that are contained, can you tell what specifically each of those envelopes are?
Yes, these are swabbings that were created from the gun that was submitted by the Atlanta Police Department.
And do you see on each of those packages the initials of the scientist that authored the report that states as Exhibit 309?
Yes, these are his initials right here and the date in which he opened and then sealed this package. And same for this one.
Right? And do the packages that you see there appear to be altered or changed in any way outside of the tape and the initialing that happened there?
I did not handle the evidence, but based on what I know, it does not look to be altered.
And each of those A and B there of 459, I think it is. Is that right? Yes. Okay, so 459 A and B, does it have a unique barcode or number anywhere on the outside of the exhibit?
Yes, it does.
And do those match the number that you just told the jury about on the other piece of evidence?
Yes, it does.
Were those items received from the Atlanta Police Department as well?
These were created in-house at GBI by a scientist. She took the swabbings from the gun and we created that evidence and attached it to this case.
Okay, when you say that she took the swabbings from the gun, is it the item that you received from the Atlanta Police Department?
Yes.
Right, I'm going to show you State's Exhibit 369. It's already in evidence. And take a look at that for me and let me know if you recognize that same unique GBI case number.
Yes.
based on the markings that you'll see on 369, is that the weapon where the swabbings were created from for 59?
I see the initials of the scientist who made the swabbings. Again, I didn't actually handle the evidence, but the initials match who the swabbings were made from.
Okay, and from what parts of the gun in 369 did the swabbings come from?
It says here that the swabbings were made from the trigger and from the grip.
And if you could,
From the wheel.
The trigger and the grip.
understanding that 369 has been made safe, please open that for me, and if you could show the jurors what parts of the gun we're talking about when we say swabbings from the trigger and the grip. Notebook.
So, just want to make sure, I didn't actually touch this evidence, this is the first time I'm seeing it. But based on the description, the trigger would have been this piece here. It would have swabbed right in here. And the grip would have been this area where the texture is probably on both sides. Because it's also the same on the other side.
And as part of your work at the GBI, have you actually handled a case where there's swabbings that you're using for DNA testing before?
Yes.
And when we are telling the jury about a swabbing, how does that process actually work, where you're taking a swab from a piece of physical evidence?
Sorry.
Okay.
We take a brand new swab and we moisten it with water. We then rub essentially on the areas of interest where we think DNA would be. We then come back through with a new dry swab to collect anything we may have loosened up the first time, and those are the swabs we then test.
Okay, so let's start from the beginning. We know you received a gun that eventually led to swabbings in this case. What's the first step of the testing process there at the GBI for this particular evidence?
We cut a piece of the swab into a tube, and we're doing this to remove the DNA from the swabs. Once we remove the DNA from the swabs, we then determine how much DNA was obtained. Once we know that step, we then make copies of the DNA at specific locations. In this case, we are looking at 16 different locations. After copying the DNA, we generate a DNA profile, being this as a graph with peaks on it. It's just a visual representation. We use that from unknown samples and compare it to known individuals to see if there is a match or no match, and then we'll issue a report on the findings.
And so tell the jurors, when we are going through the steps of DNA testing, what is DNA?
DNA stands for deoxyribonucleic acid. It's the genetic blueprint that makes us who we are. We get half from our mother and half from our father, and it's unique to each individual with the exception of identical siblings.
And every time that someone touches an item or touches a surface, do you leave DNA?
Yes.
Is there always a testable amount or a amount that is enough for you all to test and create a profile from?
In those types of situations, there's many times where we don't have enough DNA left behind to test.
Okay, talk about that in a second. Let's tell the jurors for this, the steps that you just described to the jury, are those the steps that were taken from this particular scientist to test the trigger and the grip of the gun in 369?
Yes.
And let's start with the grip of the gun, the actual handle that you just showed the jurors. What was the result or conclusion of the scientist that did the testing in this case?
May I review the report?
Sure.
The DNA obtained from the swabs recovered from the grip of item 2A, item 4, contained the alleles of at least one individual. Due to limited data, no conclusive determination can be made as to the donors of the DNA alleles.
Okay, and when you say limited data, what does that mean for the GBI's purposes? What does that mean to you?
We did not have enough information to draw any conclusions on.
Just talking about the grip, did you have enough information to even create the profile that you told the jurors about that you would eventually compare to anybody else?
We were able to create a profile, but we just didn't have enough information from that profile to make that comparison.
Okay, what about the trigger?
PCR amplification procedures were not performed on the swabs recovered from the trigger of item 2A due to the absence of quantifiable human DNA.
So for the trigger, there was no DNA found at all that was quantifiable.
That is correct.
So let's tell the jury about some of the things that can affect whether or not you all find DNA, or if you find DNA that's enough to actually test.
So for example, the grit is textured. So texture surfaces tend to help you slough off skin cells more. You tend to get a lot more DNA from that. Smooth surfaces, there's nothing rubbing against you, so it's not going to have a lot of DNA. It also depends on if something's between you and that surface. So like me touching the paper, I'm not going to leave anything on the table. It also depends if you're sweating, not sweating. If you handle the object a lot or a little, different things like that affect how much DNA is left behind when we're talking about touch or contact DNA, which is what was done in this case.
And does the amount of time that you handle the object potentially affect how or if you leave, how much or if you leave DNA on a surface?
Yes.
If there, you talked about if there is an item in between the surface and the actual contact of the person, does that apply to multiple different types of items? So fabric, plastic, paper?
Yes.
So the presence of a plastic bag in between the trigger and someone's hand or finger, could that potentially affect the quantity or presence of DNA?
Yes.
And is it the same for the grit portion that we've been talking about with the jurors?
Yes, it is.
For either of the swabbings that came from the gun, that came from the Atlanta Police Department, were you able to get a profile that you could compare to a known individual?
No, I was not.
And once the testing for this particular scientist and now you was completed, did that complete your involvement and that scientist's involvement in this particular case?
Yes, it did.
Just one. Okay, I don't have any other questions, Your Honor.
Mr. Harvey, questions for our expert in forensic biology?
I'm being threatened by my co-counsel. Yes.
Okay.
But briefly. It's the first time I've said that, okay? Good evening, how are you?
Good evening, how are you?
I'm doing fine, thank you. I get it that you did not perform these tests, correct?
No, I did not.
All right. What you did was you got somebody else's report, you reviewed it and said, hey, this looks good.
Yes, I made sure it was accurate and correct.
Yeah, right. You looked at it and said, oh yeah, this looks accurate and correct, right? So here's what we got. I understand that on or about September 28th of 2016 is when the weapon that you've identified for us was transmitted to the crime lab, correct?
Yes.
Do you know when this event occurred?
No.
Okay. But on 9/28, the firearm was transmitted to the crime lab, correct?
Yes.
It was transmitted to the crime lab by the Atlanta Police Department, correct?
Yes.
Okay. Do you know whether or not there was a plastic bag that got transmitted with that weapon?
No, I do.
Okay. Do you know whether or not a plastic bag was transmitted with the weapon to your division for DNA testing? Doesn't look like it.
No, I do not.
Okay, well, do you see that it was transmitted to your division for DNA testing?
No.
Okay. So, the report that you've indicated is you got a gun from the APD, you did some internal swabs pretty soon thereafter. Swabs were done, I think, on 10/4 of 2016, is that correct?
Yes.
The report, do you know when the testing was done?
May I review my notes?
Beg your pardon?
She'd like to look at her notes.
Of course.
Sure.
The testing was performed in the end of November.
Okay.
Thank you for asking, Mr. Harvey.
9/28, gun, 10/4, 4 swabs. Tell me again.
The testing was performed starting on November 29th, 2016.
11/29. Testing, and the date of the report?
Report date says December 7th.
All of that done in 2016, right?
Correct.
Okay. And what I understand that the ultimate conclusions were nothing, right?
Correct.
Okay, good, thanks. Ms. Convery.
Very briefly. I'm going to show you 2 items that have been marked as 388 and 387. This one, 388. Take a look at that for me. And let me know if on State Exhibit 388 you see any unique GBI markings.
There's a GBI barcode with unique GBI case number.
And do you see any tape or other adhesive that correspond to GBI as well?
I'm sorry, what's your question?
Tape or any other adhesive that corresponds to the GBI as well?
Looks like this blue tape down here corresponds to a testing done by GBI.
The unique GBI number that we've been talking about, is that contained there as well?
Yes.
And tell the jurors what's contained in that exhibit based on the GBI label there on the front.
It just says sealed package containing evidence.
And is there a marking about what specific evidence is inside?
I would object to that as being hearsay at this particular point.
That's fine, Your Honor. We'll move on. I'm another witness. The testing, or sort of the timeline of the testing that we talked about up there, that Mr. Harvey asked you about, is there anything about the difference in time here on the 10/4 and 11/29 date that would affect whether or not you're able to get DNA from the swabbings from that weapon?
No, there's not.
Why not?
Once we take the swabbings from the item of evidence, they're stored properly to maintain the integrity of the DNA.
And so if there was a quantifiable amount of DNA on the swabs that you had, you would have been able to detect that during the testing process afterwards.
That is correct.
And nothing about that timeline, based on your training and experience, is going to affect the conclusion that you testified about in your report.
No.
I don't have any other questions.
Questions from the jurors for? Oh, it's going to be a microbiologist. Coming in now. Thank you. Is there a critical time frame for conducting the testing? In other words, you get a swab, is there a clock ticking whereby if you don't do the testing of the swab by that time, you might as well not have swabbed it?
No, there is not.
Do you know who in the chain of evidence collection and submission determines what is sent to your lab for analysis?
Whoever's submitting the evidence usually decides what requests they want and what evidence they want tested.
Was the PCR amplification profile obtained from the swabs from the gun compared to the DNA amplification profile of the defendant's DNA?
At the time of this testing, we did not have a known submitted from the defendant. And like I said, the DNA profile obtained is No conclusive. And means that even if we had a known from the defendant, no comparisons would have been made.
Because of the lack of conclusivity of the work your colleague did, you wouldn't have tried to make a match with anyone's DNA, is what you're saying?
Yes, that's correct.
Okay. Do you know from what tissue or surface of the defendant's body the swabbing or extraction was made?
Usually you use your hands on guns. So in theory, it should have been from skin cells. We have no way to definitively test for skin cells or know where the DNA came from, but based on the fact that you handle a gun with your hands, it should be skin cells.
Okay, but you don't know from what part of the defendant's body skin cells were gathered?
No, it could be from having rubbed against a leg, an arm, any skin cells in general.
I'm not asking the question well. It sounds like at some point there was a known sample provided to the crime lab.
Wait.
Is that not?
That's not.
Oh, okay, I thought you said at some point you received a sample. Did I misunderstand what you said?
I'm confused.
When you were answering the question about the PCR amplification being compared with the DNA amplification, you said we didn't because something wasn't conclusive. But you also said we did get a known sample of something. Did I misunderstand what
At
you
the
said?
time of this testing, I didn't have a known from the defendant.
Okay.
I only had a known from, it says, Landa McIver.
Okay. Do you know if the crime lab ever received a known from the defendant?
I do not.
Okay. I misunderstood what you said. Do you have any follow-up based on that, Ms. Conford?
I do, Your Honor. Ms. Carroll, for the next step in the analysis that we've been just talking about, the comparison to the knowns of either Diane McIver or the defendant, did your testing make it to that next step of comparison?
No, it did not.
And did it not make it because of lack of conclusion or because of lack of amount of DNA on the item, the gun that you actually tested?
For one item, it was we didn't even have DNA to compare to. The other item is we had DNA, but it was so limited that you could not make a comparison.
And when you say limited, are you talking about the quantity of DNA that was actually present on the surface you tested?
Yes.
So in one instance on the grip, we've got a really low quantity of DNA, and then on the trigger, you actually found no DNA at all.
That is correct.
The police agency that we talked about earlier submitting the items, the Atlanta Police Department, is that an example of the agency you're talking about that actually sends in items and requests services from GBI?
That is correct.
So at the time of this testing only, the testing you're talking about, if you had a known from the defendant of any skin cells, any part of the body, would that have mattered for the purposes of what you had there from that gun?
No, it would not.
Why not?
It would have never been compared.
Because of the quantity?
Yes.
Okay. Those are all my questions.
Mr. Harvey, any follow-up? Okay. Your choice. Thank you. Ms. Carroll, you are free to go. Appreciate your time.
Thank you.
459, did it get admitted?
Is it response?
Correct.
I just had to identify.
Okay. Got it. Okay. Ladies and gentlemen, this would be one of those times you reference where it's not quite 6, but it's a natural break point. So I'm going to say let's bid each other adieu until tomorrow morning. Enjoy your Tuesday evening. We'll see you tomorrow, 9 a.m. to get going. I have an 8:30 meeting across the street with a county commissioner, and so I will be doing my best to say I gotta go. But as a county commissioner, so get here as close to 9 as you can, and I will make the same effort to get here as close to 9 as I can. And we'll see who the state has next for us. Thank you for your time. No outside research. Don't read about the case. See you in the morning.
All rise for the exit of the jury.
You all should have, did you get letters? If not, you'll get them in the morning. Ms. Hansberry is putting together a letter. One of you had asked for it specifically, but it's a letter that says, you've been busy, you get a week off, but then you need to come back. And that may be something that you need to convince people that we're really serious about this. Thank you. All right, you all can be seated. Mr. Rucker, is there anything we need to work through from the state?
No, we should have videos redacted and in a form that we can share with defense that would take out all of the Mark Lee-isms and limit it strictly to statements from the defendant.
It'd be interesting to see. It's sort of like a professional football game. If you play the actual, it's like a 3-minute event, even though it's a 3-hour thing. A Mark Winnie story, when someone else is talking, how long is that? We'll see. Okay. Has Mr. Samuel been advised as to what might be in it, or it will be news to him when he gets it?
It will always be news, because that's what it is. There's no way it's going to work. I'm just predicting, and I'm telling them, I can't. We're building a relationship. Still, if you just look at, take it home with you tonight and look at 5 total minutes, I love these reporters in case they're watching, but they're so over the top in their descriptions and the tone of voice in which the questions are asked and the images that are portrayed while the questions are being asked, jail doors slamming shut. I'm not trying to overdo it, Judge. That's what the TV does. If you want to get a statement of the defendant, they should put a witness on the stand. They can put a mannequin on the stand and say, what did the defendant say? He said X, Y, Z. What more do they need? Why do they need to do, a news show which clearly is not designed to get a specific statement from the defendant? Put an actor on the stand. What did Mr. McIver say? Mr. McIver said X, Y, Z. Next question.
2 things. One, I think we all need to react to what is actually shared in the morning, and I'll do that, and I know Mr. Samuel will, and maybe he'll repeat his reaction now, which is a repetition of his reaction earlier, and I appreciate his observations. But the second thing, you are saying in seriousness, almost like turn this into how a deposition is read into the record, rather than it being whatever it looks like on the screen. It would be, these are the parts to which we have no objection, and they would come in, and it would be clear that they are 100% attributable to Mr. McIver.
Yes.
Okay. Well, there's a plan B. If plan A.
The questions are, tailored so you don't get all the garbage in there, and that way you get rid of the jail problem. You get rid of the clanging doors. You get rid of all the video. The videos. I don't know what the terminology is, but you have the indictment plastered over his face, kind of thing. And graphics.
Sure.
And so, yes. My guess is they're going to see so little of real substance of what Mr. McIver says that they're going to lose the whole thing will take about 30 seconds.
Okay, well, we'll see what the video looks like in the morning, and we have a plan B as well. And maybe you all come up with a plan C.
The jail stuff is just like the jail call. I mean, what about the jail call that the jury gets the impression or gets the ability to preview the fact that the defendant at one point was in jail. It's the same scenario.
I understand, and these jurors may well know he was in jail at one time. I don't recall what they said they knew about the case. They said that what they knew wasn't something that would influence the way they handle the case. But that doesn't mean willy-nilly we get in the fact that Mr. McIver was intermittently in custody. There may be times when it comes in, there may be times when it's appropriate. Mr. Samuel has said that's one of the concerns he has about the interviews that Mr. McIver arranged while he was in custody. So we'll see how we work through all that. Anything else from the state?
I'm going to try to get it to you tonight so that we can prepare and talk about it in the morning.
Great.
What are you going to get to with that? The video. You're going to redact the video.
Okay.
He'll watch it. He's told us it's super short, so it can't take long to watch what's getting shorter still. All right, anything from the defense? All right.
You don't put any time tomorrow by any chance, or we just ask them each day?
we find out in the morning. I think they tried to make this week all 6 o'clock. So we know Friday won't be, but I think they tried to do that. And then we got the note this morning because it was recognizing, gosh, you're making us come back anyway, so maybe we don't need to stay till 6 each night. But I appreciate everyone making themselves available. We've got a whole other witnessing this evening. See you in the morning.